So I think we should begin by introducing ourselves, because I'm not sure how many police stations are represented here. Okay.
From Ranipur.
Okay.
From Colin PS.
Okay.
From Jordan PS.
Morning, ma'am. Here is one from the Putia from Sikkim.
From Singtam. Okay.
Morning, ma'am. Here is Visalama from Kubuk.
Kaluk, sir?
Kubuk, ma'am.
Kubuk. Oh, okay.
Here is Gangtok.
Okay. Okay.
Morning. Here Vicky Suna from Lachin.
Okay. At the back, what do we have?
Good morning, ma'am. S.I. Chandra Kumar Siddharth from
Yes.
Good morning, ma'am. S.I. Rajesh Chandra Vijay from Barphungpa PS.
Okay.
Good morning. Haribaran from Communication.
Okay. Communication.
Good morning, ma'am. P.I. Kumar Gurung from Communication Branch.
Okay.
From Nirmal Rai Communication.
Okay.
Good morning, ma'am. A.S. Manjit Thapa from Communication Branch.
Okay. Thank you so much, everybody. I'm familiar having worked with you all. Some of you are new to me. I'm sure at some point, although you all may be in communications or human trafficking, you will be back to your police stations. So I'm grateful that you all have spared your time to come and talk to us today. Be with us today. I think you have got the schedule. Number 1 says challenges. Now, this is something that I will take up in the second half of my lecture, all right? Because I think this is very important to all of you. Challenges say it says challenges and problems faced by the investigating officers. So, I think you need to participate. You have to tell us what are the challenges. We won't know most of the time what are the challenges faced by you, no? So, I will want you to tell me what challenges you have. So, I've requested our learned director also to sit with me because he's also had a lot of experience in POCSO cases, and as the courts we've also faced certain challenges while dealing with these POCSO cases. So it's a good thing that this topic we will address it together. Alright? So now moving on to part 2 and 3 of our timetable today. First we'll start with understanding POCSO. POCSO Act. Understanding the POCSO Act. I've got a short PPT. You can be reading that, but basically I'll just be... Where is it? What do you understand of POCSO? Anybody? Acha, how many of you have handled POCSO cases? Just put up your hands. Okay, excellent. Many of you have handled POCSO. And I think Katizanata Asti, were you here? I know some of you were here. In just 4 months ago, we had one program on POCSO here in SJ. Tapan on Barphungpa, Katizana? No. I think you, a couple of you were here, so it's more or less the same thing. There we had other departments also, but since this is investigation specific, enforced on a very significant day, Children's Day, November 14th, Children's Day, about 11 वर्ष अगाडि, it was launched in 2012, no? So, just 1 second. 10 years of POCSO, of the POCSO Act. So why do you think the POCSO Act was required? It came out about recently, 10 years, but why do you think we needed an act like POCSO?
The mere child was not covered earlier.
Very good, yeah. Because why do you think they were not covered? What were the difficulties? You all might have investigated also, no? Did you all, about 10 years ago, I don't think anybody, you are too young, I think, no, to investigate. Anyways, so hamro time, let me say, during my time when we started, no, we had only the IPC. You know, you had section 375, 376, and there was no, it was not that there were no child victims. rape victims huन्थ्यो, नानीहरू हुन्थ्यो, but then courts were finding it so difficult. Even the investigating officers found it difficult when the victim was a child. And a child victim, adult rape victim, they had to be treated on an equal footing. अब तपाईहरुलाई you know very well, एउटा investigation मा एउटा child examine गर्दा एउटा adult examine गर्दा, there's a vast difference, no? तपाईहरु you face so many problems. So even the courts faced lot of problems. It's very difficult to examine a child, and that also a child of a sexual assault, child who is a victim of rape, and then trying to adjudicate on a case of such a nature at the same level as an adult victim. The courts and the legislatures found that we need to take out a legislation which protects the child and which is specially drafted for a child. So that is why we have the POCSO. And the title of the, I think you'll see, the title of the act itself says Protection of Children from Sexual Offences. Now, every act has a purpose and objective. And the objective of POCSO is there in the title itself. The main thing of this act is to protect children from sexual offences. That is the main act. And why we have a separate act is because now the act says we have to treat the children of sexual offences as a different class. Different class. So that is why you have the POCSO Act. And unlike before, sexual offences, IPC ma, what sections did you have? Anybody? Exactly. Apart from rape and 354, nothing else. But I'm sure you have come across so many different degrees of sexual assault. So many different kinds of sexual assaults, which there was no law to address such cases. So that is why now the POCSO Act is it tries to bring under its umbrella all the different kinds of assaults, all the different types of sexual offences. And it is just physical. Offences just physical, no. Either it's rape or outraging the modesty. Outraging the modesty for the police and for the courts to convict an accused under outraging of modesty was so difficult. What is modesty? Modesty is a lady modesty is one lady might get outraged, she get very angry with that act, they might be very offended. They might take it very lightly. They might think that, how dare you touch me? For others, they will think it's normal. So it was very difficult for courts and the investigating officers also to bring people under this act, under this offense, outraging of modesty. I think many of you all might have heard the famous case of APS Gill, outraging the modesty Banera. Have you all heard? He was the DGP, Punjab, no? Famous case. The lady was involved, was also a very highly placed police officer. And what happened was during a party, Mr. Gill he just slapped her backside. Our colleague he patted her on the back, she made a complaint. So this became one of the landmark judgments for defining what is outraging the modesty of a woman. Because she said that any touch that makes me uncomfortable, makes a lady uncomfortable, is outraging my modesty. Mero modesty, what is the, I don't know, Hindi or Nepali ma, what would be the appropriate word? Modesty? Izzat bhanda pani, yeah, maybe izzat. No, any other word you think? Yeah, izzat, right? Anything, malai alikati uncomfortable lagyo bhane chai You can say if the child or the lady finds discomfort in the touch or the word, it can be outraging of modesty. It is not necessary that luga ukalnai parcha ya pura body touch garnai parcha. No. So if the complainant feels like that, then of course it can be outraging of modesty. But now coming back to POCSO. POCSO case le ke garcha bhane, I think you don't have it. Forget it. Okay. Do you all have the POCSO Act with you? No, eh? You can note down. POCSO Act, let's say, it defines different kinds of sexual offences. I think many of the investigating officers will know. Different kinds of sexual offences. And then it doesn't just have sexual offence, it has sexual offences, aggravated sexual offence, means a more serious form of that sexual assault. Then you have penetrative sexual assault. It can be just sexual assault also, but it can be a more serious form of sexual assault also. Then you can have penetrative sexual assault. Then you can have aggravated. Aggravated means a more serious form of that sexual assault. And these assaults are described now. Chapter 2 describes the different forms. Section 3 is penetrative sexual assault. Section 4 is the punishment, mild, right? Punishment says sexual assault. What is the sexual assault? Penetrative sexual assault is, it's described, no? You just have to see, I don't have to tell you what will amount to penetrative sexual assault. So then this could say, penal section is section 4. But a penetrative sexual assault, there's a more serious form of penetrative sexual assault. And that is section 5 again, aggravated penetrative sexual assault. And this section gives you a whole list how it can be sexual assault. Aggravated, serious kina huncha. Penetrative, it's the same act. Act the eutai bhayo. But why would it be aggravated? Why is it more serious than a normal penetrative sexual assault? It will become penetrative sexual assault when it is done by somebody who is, number one, whoever being on the management, might be a school, home, hospital, police, anybody who's in an institution under whose care the child is. So likewise, if the child is below 6, all this, if you go through this, your specific, every fact and circumstances of a case will be applicable. Investigation, which category will it fall under? 5, you have from 5 A to J, Q, R, S, T, U, till U, different categories. You can pick any one of these if you find that it is a sexual assault, or aggravated form of sexual assault. And for this, the punishment is again more serious than section 4. Section 6 says it will be not less than 20 years, but which may go up to life imprisonment. Now, when the POCSO Act first came out, it was not so serious, the penal provision. But it got amended in 2019, I think. And now this offense is very serious. Minimum they've made it 20 years. I think it was 10 years. Now it's 20 years. And it can go up to life. They felt that people did not take it seriously because after 10 years, they'll be out. Supposing your perpetrator was 21 years old. After 10 years, even if he got minimum 10 years, he's still a young man, he's 31 years old. But what happens? The victim is ruined for life, no? So now that is why the legislation has amended the penal provision and now it's more serious. So section 6 has been amended. And then again section 7 is lesser, sexual assault mate. You have simple sexual assault. What is sexual assault? Whoever touches any part of the child's body, private part, or with sexual intent. Now here you have to be a little careful with sexual intent. Right? Sometimes you might touch it accidentally, but child might complain, no? And that here you have to do fair investigation. No? If you are prima facie investigation, you are convinced it was not sexual, maybe it was not sexual assault. But sometimes if you are borderline, no, you might have done, with sexual intent, your charge sheet will be filed. Then of course it is up to the court. I'll give you one example. Sexual assault I don't know, maybe one of you might have filed a charge sheet. A case came, one adult and about 3-4 children. Pani parday थियो. The adult male was the father of one of the children. Girls, है? सबैजना साथीहरू बस्तीमा अब they went to the दोकान हैन? दोकानमा सामान किन्दाखेरि चाहिँ the father was also there and it was raining. So अन्त अब बस्तीको बाटो हैन, how it is, it's rough. So कोही नानीहरु चाहिँ कुद्दै गयो and the father said whoever reaches home first will म उलाई मिठाई दिन्छु. So 2-3 जना अगाडि कुद्दै गयो. एकजना चाहिँ अगाडि हिँड्दै गयो. One child चाहिँ she was coughing or something. The father said, "You come with me under the umbrella," because there was only one umbrella. Now he had an umbrella, so look, Muslim. So they were walking. Road is rough, raining heavily. When the child reached home, she started crying. And the father ke bhayo bhandakiri, she said that her father and this accused, they are good friends. Chimiki ho, chini raheko, हैन? So she said that uncle le ta malai juma hat lagayo. Naturally, being a father, he was very offended and he confronted him. Then he said, now people are very aware. So they went to the thana, lodged a report, case register bhayo. At the time of recording evidence now, the child, I don't know whether she turned hostile or whether she gave a true account, but she said that, I know हिँड्दै थियो and छाता बोक्दाखेरि I thought he was touching me with his elbow, हैन, touching my breast. And बिजो नानी भनेर यसो तान्दाखेरि I thought I felt uncomfortable. But she said, तर त्यस्तो गरेको जस्तो लागेन again. So now it's very difficult for the court also to assess. No, but eventually all the witnesses, like the father also turned hostile. He said, "Oh, I lodged the complaint, but actually this to ke thena," complainant also. So eventually he was acquitted based on the evidence. But herein lies the danger. These are the challenges you might face. It might have been, it might not have been. The danger of, again, awareness is also that children are so now attuned to bad touch and good touch. Din rat school they are being drilled with what is good touch, what is bad touch. The minute they feel that, oh, they are looking out for a bad touch, jasto bhaisakyo हैन अहिले चाहिँ situation त्यस्तो भइसक्यो. On the other hand, of course, there's a good side also that now children are aware, so they are protected by the act, which is the object of the act. So these things also happen. So anyways, coming back to the section, so section 7 deals with simple assault like this, no? But when you say that they touch the body, it must be with sexual intent. This is the main thing, sexual assault. This is the simplest form of sexual assault. Then you have aggravated, for which, okay, section 7, then penal section is punishment for a term which shall not be less than 3 years. But which may extend to fine and with fine. Right? Then you have aggravated form of sexual assault. Not penetrative, but just sexual assault. So what is that? So again you have all degree. Section 9 it describes up till V. Different forms of sexual assault. Again, like aggravated penetrative sexual assault, you have different forms of sexual assault. Then, unlike earlier, you also have sexual harassment. Penetrative bio, aggravated penetrative sexual assault, aggravated sexual assault. But other than that, you also have now sexual harassment, which was not there before. Before the sexual harassment, modesty, it would come under the same thing, 354. I would say now you have a specific section, which is section 11. Section 11 is sexual harassment. Anybody who utters a word also, if you just say something obscene, utters a word or makes any sound or makes a gesture, you might not make a sound, you might not say anything, but if you make any gesture, you do any act, right? Which, or if you even show slang you say no flashing bhन्छ नि flashing. You just exhibit any part of your body. You expose your private part to the children. This now it will amount to sexual harassment. Before all these things were not specified, but now the Act specifies it. So what it is trying to do is take in every kind of sexual assault, every kind of obscene gesture, sound, movement, anything which might expose the child to sexual assault. Right? So here, utters any word, makes any sound, makes a child exhibit. Even if he makes the child, then you have certain perpetrators who don't do. They'll say that I didn't even touch, I didn't make a sound, I didn't make any gesture. But what does he do? He makes the child do it. He will make the child expose parts of himself or herself. Now such cases can also come under sexual assault. So it says, makes a child exhibit his body or any part of his body so it is seen by such person or any other person. I know. Shows any object to a child in any form or media for pornographic purpose. Now this is something which is happening very often but not reported. They will call the child, come sit. They will not do anything. Mobile khol dincha. They will open a pornographic site. See. The child doesn't know, bichara. The child now is exposed to pornography. And investigation garda ke huncha? Did he touch you? No. Did he say anything? The child will say no. Did he make any gesture? के गर्यो? मे sound बनायो? छाडा के बोल्यो? Nothing. Then what did he do? Phone खेलाउन दियो. Now the child might not be able to say what she saw in the phone. How will she describe pornography? Isn't it? So, but during investigation, this is how you deal with the child when you are investigating. Then slowly the child might come out and say what she saw, what she was exposed to. It might not be the mobile. He might have shown magazines, might have shown pictures. के गर्यो हैन कोठामा बसिरहेको थियो के गरेन हामी गफ गर्यो किताबहरु हेर्यो त्यति हो. But then it might be a normal magazine, but inside you might have one or two pictures which were obscene, might be pornographic. So here these are situations which will come under sexual assault. Or repeatedly or constantly follows now. अब देखाउनु पनि परेन, भन्नु पनि परेन, gesture पनि गर्नु परेन, but stalking starts following the child, watches the child. हेरिबस्यो नानीलाई. Repeatedly or constantly follows or watches the child either directly or through electronic, digital or other means. Threatens or uses any form of media. Now these kind of cases are coming up with the use of technology. Sometimes stalking it is, you will understand stalking है कतिजना school girls like, yes, it might be school boys also. They start following. केही गर्दैन, छाउमा पनि आउँदैन. They will start following at a distance. Yeah, school आउने बेलामा they might have a crush on the child or they might have sexual intent. But के गर्छ स्कुलको बाहिर गेटको छाउमा बसिबस्छ, पर्खिबस्छ, या wait for the child to come after school. There have been cases where taxi drivers come. यो नानी निक्लिन्छ. They'll be waiting with the taxi. ठक्कै त्यो त्यति बेला चाहिँ स्कुलको छेउमा आइपुग्छ. Then they'll offer a lift. They'll say, oh, I'll drop you or I'll pick you. But they start watching, they start following, and it might reach a point where they will become bold enough to do some act and subject the child to sexual assault, some form of sexual assault. So these are different circumstances where POCSO Act, let's say, they try to bring the perpetrators under this act, so that at least What is the purpose? To protect the child, so that the child is protected from such people. Right? So just not just by doing the actual act, then by saying, by doing, by showing, just by following, just by watching. Now the next thing is stalking, physically the stalking, I told you how. Stalking through electronic means. You can stalk a person, constantly open the child's Facebook page, you look at the child's Instagram page. There are so many, Twitter, God knows what you have nowadays, right? Always looking at the child. So these are also forms of sexual assault which will be brought under this act. Arko ke cha bhane, they will take pictures of the child. They'll say, "Ma naksha khichidinchu, come, let's do this, let's do that." They might modify the picture. Or sometimes there are so many cases where they get into boyfriend, girlfriend huncha, then naksha khitcha, then they will take clothes off, they will make the girl, even if they are not together, when the girl is in her own house, under the protection of her own parents, living in the same house, and next room, she will be subjected to sexual assault. How? Through electronic means. Your child will be subjected to pornography, your child will be subjected to stalking, your child will be made to show parts of her body to her boyfriend, whoever. It will be happening under your roof, in your house. And that is so dangerous. That is how sexual assault is happening. Your nani bairo pani hunu pardaina. It will be happening right inside your own house. And after that, she will be again threatened. If you don't do this with me, I will show this. If you don't do this, I will doctor this, and I will make it more sexual, and I will put it on social media. I'll share it in your group. So the child gets more and more drawn into this offense. And so many times they will use these few pictures to entice the girl to run away, knowing the girl is below 18 years old. So these are the various forms of sexual assault. So that is why POCSO has come out, because earlier all these circumstances were not covered in the IPC. Now the investigating officers have a whole range to help you with. Investigation, you just, if you have the act with you, keep it. Offenses are key offenses. What is the offense committed? You just have to read chapter 2 देखि तपाईको chapter 2 till chapter 4. All the different kinds of offenses. These chapters are dedicated solely to the different kinds of offenses that you might find while investigating a case. Alright? And then there is, of course, abetment. The next chapter, chapter 4, is abetment. Anybody who abets, anybody who abets with or who attempts in the commission of an offense under this act, unako abetment ko lagi pani, there is a section called section 16. Now, section 3 deals with using the child for pornographic means. A child will not know. A child is playing, especially summer and all, kattu ra ganji lagaera matrai naniharu kudiraeko huncha हैन. The adult might say, come, garam lagyo, I'll give you a bath, or I'll hose chalaउँछ नि के भन्छ पाइपमा पानी लगाइदिन्छु, come, it's very hot, come. They will come up with all kinds of situations. They will make the child nude, they will take pornographic pictures, then they might start taking videos, or they might get two children together and play with each other. They will not do anything. They will make the children do it, but they will start taking pictures. So, using child for pornography. Again, this is another new form of sexual assault that has come out. The child will not know, but sometimes when they are talking to their parents or friends, these things come out. And then when you investigate, you find out that actually with sexual intent this tobacco. So these are again different forms of sexual assault, which is using the child for pornographic purposes, and then again the punishment is going. Now chapter 5 is very important for investigating officers. Chapter 5, why? Because chapter 5 मा चाहिँ तपाईको section 19 छ. तपाईले चाहिँ यो चाहिँ if you have the act, if you are investigating, you use this as your handbook. Use the act as your handbook. Chapter 19 will deal with reporting of offences. Now when will you come to know about an offence? When somebody comes and tells you, isn't it? Who will come? Child line ko manje aउँछ, या teachers, parents, and then they will bring the child. Now here say this will be your guidelines. Now along with chapter section 19, you will have to see your rules. तपाईहरुले कतिचोटी चाहिँ तपाईहरुलाई इन्भेस्टिगेसन गर्दाखेरि ला यस्तो सिचुएसन भयो, what is to be done? Now you don't know what to do, no? Always I advise you, look at the rules, because every time everybody focuses only on the act, section भन्छ नि तपाई. Nobody actually looks at the rules, but the rules are your handbook. The rules will tell you, rules will help you how to do, why to do, when to do. Alright, it's like investigation गर्दाखेरि पनि, I'm sure तपाईहरुको ट्रेनिङहरुमा पनि they must be teaching you, no? W4H1 भनेर. Come, you can write it here on the whiteboard. आउनुस् त. Come. Any volunteer, anybody who would like to help me write on the whiteboard, come. You have your chalk? Marker, sir? You can ask your colleagues, भन्नुस् त.
11 of this.
What are they? Okay. What? Okay. When? What?
Where?
Okay.
Why?
Who? And H1? How? Yeah, very good. When, where, who? How? H भने what, हैन? What? When, where, who, what? Majid? You can add also if you want.
Why?
Okay, how, put how. How? Right? Very important, no? कहाँ भयो? कसरी? Who was it? Eh? How did it happen? किन भयो? Okay. So, likewise, in the rules also, now very important. Section 19 says first, it says reporting of the offence. When do you come to know about it? When it is reported. Right? So it says, any person including a child who has apprehension that an offence under this act is likely to be committed, now likely to be committed, has knowledge that such an offence has been committed, not necessarily that the act has to be committed. There is a likelihood, apprehension हुन्छ नि. There's a possibility that the act might happen. So likelihood of it being committed or an offence has been committed shall provide the information to who? To the special juvenile police, to the local police. And so every report given under this section will be, what must you do? What do you all do normally? Is the report आउने बित्तिकै तपाईहरु के गर्नुहुन्छ? Any volunteers? You register a case, then? Okay. Examine victim. Complainant, okay. Victim or complainant, okay. Then? Sorry? Medical, okay. Okay. Okay, excellent. Child welfare. So when you do all this, how do you do it? What is the step?
Initially, we examine the victim first,
Hmm?
then the medical will be done.
Hmm?
Then after, intimation will be given to the concerned authorities. Then after, we carry on with the arrest procedure.
Very good. So all of you know exactly what is the framework, I know. Complainant आयो, उसलाई examine गर्यो, medical लानु पर्यो, register गर्नु पर्यो, यो गर्नु पर्यो, त्यो गर्नु. यो सबै गर्नु हुँदाखेरि चाहिँ there are other things also you are required to do, which the Act mandates. Now what is that? That section 19 will tell you. The special police unit or the local police information आयो हैन. Now once the report comes, every report given under this subsection shall be ascribed an entry number and recorded in writing, which you all say you do, step 1, right? Very important factor that everybody skips. You have to read over what you have written down. Read over, and it's specified here also. Be read over to the informant. Now, these are the problem areas. Informant comes to the court, victim comes, everybody knows, report bhayo. Everybody knows, report lekyo. But these are the loopholes for the defense, no? सरले पढेर सुनाउनु भयो, तिमीले त भन्यो भने नि हैन के लेख्यो यहाँ पढेर सुनायो? The child also, अन्त सुनाएन, केही भन्नु भएन है? And they're telling the truth. Because के हुन्छ भने, I understand थानामा पनि त्यति बेला there's lot of excitement, parties are coming, हैन? There's pressure, यहाँ माथिको मान्छे त्यहाँ कराइरहेको छ, हैन? यहाँ माथिबाट फोन आइरहेको छ, यहाँ अर्को complaint आइरहेको छ. Then there is the child. You are supposed to take special steps regarding the child. In all that, these little things get forgotten. Right? So, very important. You must read out because it's mandatory. The access, you have to do it. Make sure that somebody reads it out to them. Just tell me if I've recorded it correctly or not. Or he's going to read it out to you. Just check and see if it's read out, if it's recorded correctly or not. Get somebody, depute somebody, but make sure that it goes into the head that informant or victim or whoever ki information say लेखेर तिमीलाई चाहिँ पढेर सुनाए पछि कोर्टमा सोध्दाखेरि don't forget, हैन? Okay, so तपाईले लेख्नु भयो अरे whatever stated. When you write it, oftentimes के हुन्छ भने आफ्नो थानामा you have your scribe. के भन्नुहुन्छ? Constable writer, हैन? What do you call it? Scribe हुन्छ नि लेख्ने मान्छे है तपाईहरुको. So the scribe will write. Writer Bow, famous writer Bow, right? Writer Bow will write. Nanile bhandaicha, writer Bow is so used to his format that he will write in his own language. He will use deadly words. He uses very good Nepali vocabulary. हामीले पनि नजान्ने कतिवटा words हुन्छ. Words the child is not familiar with at all. Words the informant has never said. Informant the bichara बस्तीवाला होला. उलाई पनि he will not know such words. And the court म पढेर सुनाउँछु, डिफेन्स विल से यस्तै लेखेको हो, मैले त यस्तो भनेको थिएन. So that is why it's so important to read it out to them. And then the Act says, when you write the statement, write it in very simple language. It says, when the report is given by a child, the same shall be recorded under subsection 2 in a simple language, so that the child understands the contents being recorded. This is why it specifies, because the courts have faced this problem, because investigating officers have faced this problem. Because the ISF said, "Haina hami lekheko," but the child is saying, "No, I did not give this statement." And this is why, because the language used in recording the statement is high-flown language or very formal language or language that the writer Bow is so used to. It is not simple language. Now, if the child has used specific words, use the same language. Most of the time, नानीले के भन्छ भन्नुहोस् त रिपोर्ट गर्दाखेरि What does the child say? Exactly. छाडा गर्यो. Now how it's such a general term, how do you describe it? Is it physical? Is it just oral sexual assault? Is it aggravated? Is it simple sexual assault? So when they say that, then it is your duty to, you cannot pressurize the child, you know that very well, no? To try and make the child as comfortable as possible and try to get her to explain what she or he exactly means by charagari. So these are little things that you can pick up. And another thing, very important thing, now recording bhayo, sabai garyo, but while doing that, I know the So the act says that if possible, juvenile you tapaiko was SJP or try not to be in uniform, isn't it? They use uniform. Uniform I can understand the practical difficulties. So what I would advise is about informant IO, because child will not come alone most of the time, no? So don't examine the child in the thana. Complainant ko complaint lekhnos. You are supposed to examine the child in the comfort of her home. So during investigation you have to visit the home or the PO. You know? So you examine the child there, and if you know that you are going to be examining the child, then if you have an SGPU, have that person in plain clothes, or if a lady cop is there, if it's a victim, a girl victim, lady police like plain clothes lagaidinos. These are things so that later at the time of trial, no fingers will be pointed to you to say you did not comply with the mandatory provision. So you have to try and block all the loopholes. These are small things but mandatory. In case the child is brought to the thana, because 90% of the cases, they will bring to the thana. I know, because medical garon pare. So I think in the thanas you have nowadays child-friendly rooms. I know. You have. So keep the child there. Alakai. Record the evidence of the parents or informant. Take the child for medical. Now medical gardakiri, another thing. You have to tell the doctors, despite so many, even till very recently last year, November, October, Supreme Court came down very heavily on medical examinations. 2-finger test. So many hospitals were still doing that, despite the guidelines. So you must be very careful when they are testing the medically testing the child. Then make sure that she is accompanied by a lady police officer, if a female child. Then make sure that consent is taken. This is another area Cosma we face a problem, because defense ko kaam ho to dig out all these loopholes. Consent liyo, the child's mother will say, case sodhnu bhaina medical garnu sidhai lagyo. So make sure that you request the doctor, examining doctor, ki please consent record gardinos. Sometimes they miss out also, human beings, no? Sometimes they miss out. So you can just see if consent is not.
Excuse me. Consent
for examination. Doctor. Medical form medical report you will see, no? Many of the doctors will write with consent of the consent with consent. Consent is very important. Okay, because they are all minors, no? Okay, so it says, and then if the child is a specially able child, then what happens? How will you record the evidence? Statement. बोल्न सक्दैन या dyslexic हो त्यस्तो special child भयो भने के गर्नु? So again the act says, yes, special educator or a translator. Supposing Bangladeshi victim आयो रे, which has happened. I think some of you must have had cases, no? Sometimes Bangladeshis have come, there has been instances. Language problem. Bhasha bujhdaina. Or Bengali, even for that matter, Bengali. Our director is very good in Bengali, unlike me. If somebody speaks Bengali, I will not listen. I will not understand apart from Balawasi. I don't know. You might have this problem. So try to look for somebody who knows the language so that you don't miss out what the child is trying to say. So translator or an interpreter or a special educator. Special educator when the child is differently able. Translator or interpreter when it is a different language.
Real life incident, those victims they are not like taught the sign language and all. The sign language and the problem is they have to take help of some of our family members.
Family members, yeah.
So त्यो family members include गर्दा त किन त interested party भएन. In that case defense कुनै क्वेशन गर्छ कि that हामीले त on the basis of the translator statement record गरेको हैन.
No, here what you can do is, because the courts also have the same problem, because there is one school here in, I think CJ, I think you all know, no? Specially able children, like say, there I visited and they are very good in sign language. The teachers are also very able, but basti tira hundaina aru district tira chaina, so like you are saying, we have to use the assistance of the next friend or kin or family member who is familiar with the language. Like in one case, I found that even the family members भन्दाखेरि पनि उसको एउटा गाउँको साथी थियो victimको. That गाउँको उसको साथी knew her so well that even the family used to take her aid in helping them understand the child's language. So when that happens and you have to use the aid of the friend or family member, you record the reason. Why? Because it is in this area, we have no facility for a special educator. She is a specially able child. She does not know sign language. She has not given education from formal facilities. And the only way everybody understands, usko family, other people who understand or who communicate to her is through this person or that person. And having no option, we are using we are seeking the assistance of such person. Defense door is closed.
And that thing should be written in the 161 statement.
In your charge sheet. Because eventually that is your report, no? 161 ma tamaile record garnos whatever is recorded, or below that 161 ko talapati pani you can make a note, or you can reflect it in your charge sheet. Because that is the compilation of all the hard work you have done, no? Within 60 days, 90 days, within that time frame, you are trying to examine people, go to the spot, get medical done, get paperwork, get birth certificate, school ma janu dunya bharko tamaile khojininda गर्नुहुन्छ हैन within this period. But if you fail to put all that in your charge sheet, then later, even if you are trying to say in the court कि मैले यस्तो गरे त्यस्तो गर्यो, they will say, is it reflected in your charge sheet? Is it reflected in the 161? छैन. And we cannot believe you, we cannot take your word for that, isn't it? Even if the victim says also, if it is not reflected in the 161 or 164, then they will say embellishment भयो, usko statement court ma आएर improve भयो, which is a ground. Again, the law says, court ma आएर if the story is totally different or एकदमै embellished माने added on क्या, which is not there before, then you should not believe that statement, isn't it? So try to put down, like delay in lodging of the FIR. This is not just in POCSO. POCSO and rape cases matter delay, the courts are very fair. The Supreme Court has said that delay, there is obviously going to be a delay. Which woman is going to run to the police station and say malai rape bhayo? Or which family is going to say hamra nanilai yesto balatkar bhayo? They will think 10 times before exposing about their family's reputation to such a thing. Social stigmatization त हुन्छ नि गाउँमा हैन, ए फल्नाको घरमा छोरी यस्तो भएको छ है, यसको नानी त यस्तो पो भयो त. So out of fear only they will not say, except that if the panchayat says, "Abhi आजकल चाहिँ यस्तो कुरा लुकायो चाहिँ म पनि जान्छ है, you have to report," भने मात्रै they will go, हो कि हैन भन्नुस् त. So that is why even if there is delay, you can record the reasons for delay. Say, oh, the bichara unarko thana, the ghar is like 30 miles away, they have to come walking to the nearest police station. Then because they went to this person, that person, they did not know, and finally they came. So that is why there is this many days ko delay. If you explain this in your charge sheet, your investigation is excellent, isn't it?
And usually what we do is, FIR now 154, there is also a column where we can justify.
Exactly. There are the forms for you where you can say. But oftentimes what happens is these are little details that you miss out. Just I'll digress a little bit. NDPS case gardakheri, SADA case gardakheri, I know that the courts know pakka pakreko ho, ele khako ho, bhayo, but what to do? The act is such that there are so many mandatory provisions that court has to let go. अन्त छोड्दै पछि हामी कराउँदै छोड्छ हैन, थ्रेटन गर्दै छोड्छ, but what is the use? Why? Because तपाईले अब source information पायो, कुदेर गयो, यसलाई त पक्रिनुपर्छ, यो भागिहाल्छ. तपाईं स्पटमा कुद्नुहुन्छ, I understand, very sincerely you all do. But there are sections which says as soon as the officer hears, he must write in GD entry. GD entry garera, then report it. After you do it, then under 30 you have to report it to your senior officer. Sabai bhaisakyo pani send a copy to such and such under this section to your senior officer. And so many of these are mandatory, so many are not. But when there are so many lapses, tapaile yo garnu bhayo? Defense will ask, record ma is it shown that you did? Then what happens? Then the court cannot accept only that last part of your investigation, no? So if it is mandatory and if you are required to do, even if you are rushing, even if you delegate, tell somebody, you lekhi rakhai GD entry gari rakhnu, ma chai gako lu team lagera हैन. अब you all do the search, you all call SDPO, you all call a magistrate. Again I am talking, digressing a little bit. Search गर्यो ल, तिमीलाई सर्च गर्दैछ, यहाँ नोटिस लेखेको छ, नोटिस दिँदैछ लु, अब सर्च भयो, विटनेस पनि लु खोजेर ल्याऊ. But what happens, हतारमा they will not say कि, they will not, you just have to tell them, do you want to be examined before a magistrate or not, or gazetted officer, and you give him the notice, no? त्यो चाहिँ भन्नुहोस् in front of the witness. Because police is there, but the whole purpose of getting independent witness is so that it becomes more reliable तपाईको evidence. So दुईजना witness को अगाडि the witnessहरुलाई you explain to them. See, we are going to ask him, and we are going to ask him if he wants to be examined before a magistrate or a gazetted officer. सुन्नु है, को यसले को भन्छ भने. So you will say police officer, gazetted officer, whatever. And त्यहाँनि तपाईहरुले notice पनि दिनुहुन्छ हैन, section 50 whatever. What is it?
one thing त्यति बेला अप्सन दिँदा चाहिँ कोही बेला म्याजिस्ट्रेटै एभेलेबल हुँदैन, या त कोही बेला पुलिस अफिसरै हुँदैन.
No problem. No problem. You write in a charge sheet, no?
त्यो भनेको कोही बेला मतलब अप्सनल दिँदा चाहिँ एकजना मात्रै एभेलेबल हुन्छ. अप्सन दिँदा भरे म्याजिस्ट्रेट भरि बढाउँछ उसले, तर हाम्रोमा चाहिँ पुलिस अफिसर मात्रै एभेलेबल हुन्छ. त्यो नै त्यति बेला त्यस्तो प्रब्लम.
Magistrate, यस्तो छ. For example, Jorthang, you have executive magistrate, you have judicial magistrates also.
कोही बेला एसडिएम हुनुहुन्छ, तर यता हाम्रो एसडिपिओ हुनुहुन्छ. कोही बेला अप्सन माग्दा भरे म चाहिँ पुलिस अफिसरको के अरे प्रेजेन्समा आफ्नो बडी सर्च गराउँछु भनिपठाउँला अरे भरे त्यहाँदेखि फेरि कहाँ गर्नु, फेरि त्यो पाउँदैन.
No, then you can say, you can write in your charge sheet. Write in a charge sheet. If you can say, सबै खोज्यो, किनभने एउटा केसमा त्यस्तो भएको थियो. In Jorthang, I think it was. They looked, it was some छुट्टीको टाइममा के भएर चाहिँ there were no magistrates around. Officer पनि मुस्किलले पायो. But what the IO had done was he had recorded in his charge sheet.
त्यो अप्सन छ किन म्याजिस्ट्रेट पनि छैन या त पुलिस अफिसर पनि छैन भने we can हाम्रो यसमा त्यो एउटा अप्सन छ
Mm.
त्यो अनुसारको सर्च हुन सक्छ
It's very good. Use these options, but again, like I said, reflected in your charge sheet. Justify your action, no? Justify it. Then the court will also accept it. त्यति चाहिँ तपाईँले गर्नुहोस् है त्यसो गऱ्यो भने चाहिँ because anyways I'll not go into SATA because that's another long discussion altogether. We'll come back to this, right? Anyways. So okay, now after reporting, like you all said, the next step, तपाईँले medical, you're very thorough with that, right? Medical गर्यो हो, then it says send them to the nearest, give him such care within 24 hours, and then within 24 hours, like you all said, child line लाई inform गर्छ, तपाईले whoever you have to special court, whatever, all this information is given. Now, when a child is subjected to sexual assault, or forget a sexual assault, children like say कसले protect गर्नुपर्ने हो? POCSO act त निक्ल्यो, but who? It says no protection of children. Who can protect the? Who are supposed to protect the children? It starts with your home, family, no? Family. But very often it is also family members who are the perpetrators, you know? त्यस्तो हुँदाखेरि then who's the next? Teachers, yes, institutions, society, no? After family, outside your family is your afno samaj, होइन? Your neighbor, society, whoever, right? And look, afno गाउँले पनि कुरा लुकायो, समाजले पनि कुरा लुकायो. Next is who? Like you are saying, very good teachers. You go to school, your institutions, no? Then look, after that it is reported. Then who else is there? Overall, it is the state. You know, the state has the duty. Of course, your family, your society, everybody has a duty. The Act says it is an obligation on everybody. Police ko kam matra haina. You are there as parts of the hands of the state, no? Ab state to who for the state? Then for the state you have police, you have the courts, you know, all these different institutions to look after. But apart from that, because we are part of a society, man is not an island, right? We belong to society. Even the media has an obligation. So the Act specifically says, Section 20 ma dekho cha, ki obligation of media, studio and photographic facilities also. At that time we were talking about pornography, no? Kunai studio ma testo naksha print garnu ayo re, which looks like it is child like pornographic. I hope you all are having your tea, please have it. If they find that any child has photographs of a child being involved in pornography, so it is their duty. Studio or duty or printing media. See, obligation of media, studio and photographic facilities to report such cases. Because if they don't report, what happens? What happens? They are also liable, no? Section 20, no? Sorry, 22. 22 ma, I think it says that Section 19. Everybody is supposed to report. Everybody, because obligation is there on everybody. I think there are some cases where, I think one of the cases is by you only, no? For non-reporting by family members. Of course, it's difficult for family members. Bichara abo hamrai babule yeso garyo bhane ta our society is still very conservative. You know, we have not reached that stage, but now we are starting. At least some are reporting, but then some are not reporting. But the police are making them aware that you have to report because cases are being filed against family members, against panchayats, or anybody who was aware of the fact but failed to report. That means they failed in their obligation to protect the child under the Act. You know, so. But again, this we'll discuss at the time of challenges. Challenges of reporting, filing cases against persons or family members who fail to report. I think these are also areas where you all have problems. You know that. Okay, anyway, so this is the obligation part. Okay, now again section 24 is another section which will help you while recording statement of the child. It says you must record it in the presence of the child. अलग्गै त्यो पुलिससँग मात्रै यसो लगेर don't try to record. You must have somebody that the child is comfortable with, either parent or sister or guardian. Somebody, keep that person in the room, isn't it? Here I'll tell you one. A child is not going to सोध्ने बित्तिकै भटाटाटा the child ले भन्ने हैन. No matter how confident the child. I'll give you the reason why. तपाईहरु you wear this uniform, it's so smart, right? But you all don't realize the impact of your uniform. You all, more than any other members, I think in society you all enjoy such a position where you don't even have to say anything. Just the fact that you are wearing your uniform instills a sense of intimidation, I know. Police bhanyo ta, especially in our places, especially Basti tira, bhai police bhanyo ta abo you're held in such high esteem. Esteem matra haina. Dar. Along with that comes very important fear, which is very good, but at the same time, which is also very bad. Why? Fear say it will not help you during investigation, isn't it? Even if they know everything, they will not tell you because they are scared that anything about my statement might drag me also into the picture. So it can work. It's a double-edged sword for you. So that is the reason why they say do not wear your uniform when you are examining a child. Isn't it? Another thing. Okay, you are in uniform, the child is there. You must try and adopt as friendly a nature as possible while dealing with the child. And one of the techniques, although it's not mentioned here, but one of the techniques in dealing with the child is, you're tall, smart, with your uniform, so intimidating, right? You make the child sit down, you might be walking around, talking to the child, right? Child will not open up. Psychology says you must drop down to the level of the child. I don't know if you, social media, you always see this British royal family, no? Prince William with the children, you see lots of pictures. You've seen, no? Always the parents with the children, parents. One of the tactics I was reading, they adopt while bringing up the child or interacting with the child, they always drop down on the knee. The child is this big, no? But if you're talking down to the child, psychologically the child will not open up. If you come down to the level of the child, eye level of the child automatically, the brain functions in such a way that the child is automatically receptive. It's ready to listen to you. The child automatically feels comfortable because you have dropped down to their level. So the child is alikati more than before, a few degrees more open to listening to what you have to say. And if your mannerisms are child friendly, you might come out. You can start with a joke. Don't jump straight away to the offense. Talk about other things. If child friendly room, if you have crayons, drawing, toys, use those methods. I would advise you all about Nani, it's very embarrassing for the child. Child will not know the words also how to say he touched me in my vagina or in my penis, anus. It's the words they'll use child language. They will not even want to use those words. You can use the assistance of charts, body. Draw body charts or charts draw figure. You don't have to say anything also. Tell the child to write. Give them crayons, give them colorful pencils, pens. Lu dekhau ta nani yaha kun chai part ma timlai chuyo. The child will, or you can circle, tell them to circle, put an arrow. You can start not by showing them the figure. Timlai drawing garnu man parcha lu aba ma yo kaam gardakhari timi yo kheldai bas la ekchin. Haina? Like that. Or you can use the dolls. figurines, your dolls. Can you show me which part of the body? This is the leg, this is, they'll say, no, and the, okay, esto. Then the child will open up, because no child will want to communicate directly to a police, no, even if the police is in plain clothesman, knowing that he's a police or she is a police, right? Door huncha ni namile. But the child will talk through the doll. A child will talk through the chat, much easier. They will not make eye contact. But child will say, they might not look at you, but yesto garyo, testo garyo, yaha chuyo, yeso garyo, यसरी garyo. You can use two dolls. So that way the child will be much more communicative. Why I say this is about, I was talking about the uniform, no? I'll tell you an incident. Many years ago, this is witnesses le pichi case sakera, because some of the witnesses were related to me. They were jokingly telling me about the incident. I don't know if many of you all might not have been in the force also. There was one case many years ago of murder of wife by the husband who was a bank manager. You all know about that? He was eventually convicted, right? त्यसमा के भयो भने often domestic violence भइबस्थ्यो, and they used to be tenants in somebody's building, and they used to keep on hearing दिन-रात कुटपिट झगडा परेको. Husband used to get drunk and heavy domestic violence. One day चाहिँ कुट्यो, they could hear tang things breaking, and साह्रै भएर चाहिँ some of the friends were upstairs. So they went down to say, Doctor, then the man opened the door, and then by then it was quiet. By the time they went down, sab sunsan थियो. Then he said, oh, you've come, Then he said, झगडा नपर्नु so, no? दुई-तीनजना गएर यस्तो. When they entered, room bari there was breakage. Saman bui गऱ्यो. Then the inner room ma wife was sleeping by then. So the husband says, so and so, look, your friends have come, ayo, but the wife doesn't respond because later it turns out that she was dead. And of course eventually he was convicted. But now to come back to the story of the uniform. So later, and in all good faith, साथीहरूले चाहिँ यस्तो क्वेसन मिलाइदियो, फुटेको चीजहरु बरालेर अब evidence, They did not realize, because they did not know the wife had passed away, was dead. They cleared the room, safa गरिदियो, फर्क्यो. So everybody became a witness, And then courtबाट summon गयो. And the witnesses were saying, the constable who used to come with the summons, no, त्यो अब summon लिएर त आयो. तर पिच्छीसम्म when they used to see the constable, they used to tremble अरे. काम थियो अरे उसलाई देखेर. I don't know what was his name. His name was Battise or something. I believe they used to call him that constable ki. And the one day, I believe two of them were walking, the two ladies, and the arko lady when they looked and turned, it was Battise, and then they were again trembling. But because he's a policeman, because he's wearing his uniform, no, even grown-up people. My point is that even grown-up people who are government employees, educated people, a police these are डराउँछ. Until today, I'll give you an example. One of your colleagues is getting married, Juni. The card came to my house the other day, and the one boy opened the door. Police आएछ, he said. Somebody one थानाबाट कोहीले कार्ड लिएर आयो. अब he was a middle-aged boy, तर अब त्यस्तो डराउँछ police, because he was in uniform. So this is the thing, no? That is why it's so important when you're interacting, especially with children. Try to not intimidate them. Your uniform has such an impact. See, okay, so by and large, this is the main thing for you to know about the second and third part key, understanding the POCSO Act. One of the main things about POCSO Act is What do you think is so important in improving your POCSO Act? Age. Excellent age, no? I mean, child, we're always going child, but you all have such a problem determining the age. Courts have a problem determining the age, right? The law says that about section 2(1)(d, right? Section 2(d) man say child, anybody below the age of 18 months. About our grandmother could time summer. They used to get married by the time they were 15, 16. Isn't it? Even my mother was married when she was 16, 17. In fact, one of her friends said, my late mother's name was Chimila. She said, Bichara Chimila biha gardakari ta she used to study in Kalimpong convent. Uniform mai thiye ni siddhai liera aako ulai ta. At least she was still wearing a skirt and uniform, like that. So testo jamana thiyo, no? But today suddenly the law changes and says 18 years. So many people don't know in the basti still 18 years bhayo. They think it's okay. So the girls also grow up like that. And so this has become a major problem for the courts and the investigating agencies. But what to do? The law says 18, we have to follow 18. Because the law says consent is no consent by a minor. And this is one of the grey areas where you are having a problem, where we are having a problem. And even the Supreme Court, Asti Barkhari in 3 Tarik March, Supreme Court, this is a very interesting thing. Supreme Court, 3 Tarik March, what they did, they quashed one Rajasthan High Court appeal. 22 years old, the girl was 16. They had a physical relationship, girl got pregnant, had a child. Girl is saying, I consented. And then the parties asked for but FIR lodged by because girl is minor. Then the court dismissed the case. The state went in appeal. The Supreme Court just recently, they now have come they are of the view that yes, the law is there. The law is right. It says 18. But we must also do justice to the parties. So what they have considered is the fact that the girl has consistently, now it is not that only at the fag end of the trial the girl is saying, no, it was consensual. Throughout the girl is saying, from the time the matter was reported by her parents till the time she gave birth, she is saying, Kusi Raji lega ko, we were in a physical relationship. I had a consensual relationship with him. So because the girl consistently said that it was consensual, the court said then you have to do justice. Because both the parties said that as soon as she turns 18 we will marry, because court cannot say okay, get married. Again, not permissible under the law. But because of the facts and circumstances of the case, the court said, now this is an area where we have to do justice to the parties. So Rajasthan High Court ko appeal was quashed and they let the accused go. Now even the present Chief Justice of India, he has expressed concern over this. Because all the courts in the country, all the investigating officers are facing this problem. The case that I just talked to you about, Rajasthan case, how many of you can identify with cases like that? Most of you are faced with such situations. I think almost every other POCSO case is like that, isn't it? So this is something you can identify with. So here, although as a court we cannot tell you don't register the case or don't. Again, if the girl is consistently saying it's consensual, then you have no option but to conduct your investigation. FIR. Parents are very heated at that time. Parents say तपाईले आज register गरेनम त tomorrow there will be a complaint against you. थाना घेर लाउँछ हैन. So what you do is you do your investigation. You have to follow the law. You have no choice. Girl is minor, consent is no consent. You cannot say that, oh, she consented, so I am not going to. You file your charge sheet. But in your charge sheet, be fair. Say, consensual, it was consensual. You can reflect it was consensual. Girl consistently 161, 154, 164. If the girl is saying it's consensual, let it come out. Don't try to make the case into forceful. There are instances, I'll tell you, it's the investigating officer's, he's trying to do his duty. The girl has not said that there was forcible intercourse. Okay, she said we had sex. We had a physical relationship. But the I will put the word forceful, forcible. Then somewhere right above will write Zabardasti. I know in the 161. केटीले भनेको छैन. But you feel that it's part of your duty. Because that's the investigative psychic, no, तपाईहरुको कि अब हामीले त लेख्नु पर्छ हैन, otherwise it's not good investigation. No, you don't have to do that. Your duty is to do a fair investigation. It is not that because you did not write the word forceful, zabardasti, that you failed as an investigating officer. Because then it makes it easier for the court also, you know, to do justice. Like then we can follow the Supreme Court's orders and refer to this judgment and say that in such and such case, this was the views, and that is why even the investigating officer has found during investigation, he's done a fair investigation, and it's reflected in the charge sheet, reflected in the 164, reflected in the 161, that even the girl is consistently saying it's consensual, then we shouldn't do injustice to the parties. I think you can take down this judgment, State versus Rajasthan. State versus Rajasthan, State of Rajasthan versus Tarun Vaishnav and others. Tarun Vaishnav and others is very recent. Asti Barkhari 3 तारिक March को order हो. You can Google, you will find. You can read. This will all help all of you. Because what the POCSO Act does is, any act, if it is done to a child under 18 years, what will happen? It is a criminal act. It criminalizes the act. Anything? Okay, so, see, even in a national conference recently, the Chief Justice of India, Justice Chandrachud, he's a very, very, considered one of the brightest CJIs of India, because his father also used to be a CJI. He became judge at a very young age. Very innovative, very technology mapani is e-committee ko one of the main brains behind this. Right? So even he has said, legislation se change garnu ho bhanera asti bhaर्खरै in one convention, in a conference recently, just last in December, I think. He has said, in his speech said that because of this problem faced by the courts and the police, that you should change legislation now and think about these cases where the girl is 18 and it is below 18 and it is a consensual relationship. Alright? Now, in cases where the girl has not consented, now investigating of cases where the girl is below 18 years and not consented, then it is very important that you determine the age, prove the age. Now, how do you normally prove the age? Tapaile? Very good. But the first people, the best witnesses for age is who? Exactly. Parents, no? Ama. The person who gave birth, the father. Best for people to give the age is the parents, alright? But ke huncha kati choti they will lie about the age, or they will be such that bichara they are rustic people, they have no idea. Kaile janmyo त्यति बेला मकै यति भएको थियो भन्छ हो, धान रोप्दै थियो. अब you've been in situations where you've met parents like that, isn't it? So then you turn to the next thing, birth certificate. Now it's mandatory that births be institutionalized, isn't it? Even if for some institutionalized means hospital birth हुनु पर्यो. Hospital birth भएन भने even अब त्यस्तै emergency भएर घरमै जन्मियो अरे. Who would know? Asha worker. Because every Asha worker of the area is duty bound to follow up each case of pregnancy. उनीहरूको कामै थियो. Every household where a mother is pregnant, त्यो मदरको वेलफेयरको लागि हैन, कार्ड बनाउनुदेखि लिएर उसको मन्थली hospital visit, usko diet, all that is the duty of Asha worker. So the Asha worker is your best witness. त्यो Asha worker लाई याद हुन्छ from the time the mother conceived, कति महिना पुग्योदेखि जन्मेको दिनसम्म कहाँ जन्म्यो, कसरी जन्म्यो, को थियो, because it is her case. Every Asha worker has their own case sheets, no? उनीहरू आफ्नो आफ्नो number of expectant mothers वगैरह वगैरह हुन्छ हैन. All these health workers, they will have त्यो गाउँको each household को बिमारीहरू on their fingertips. Even if a sexual offense happens and the child, it is not reported early, every chance that the Asha worker will know. Somebody might tell the Asha worker, यो नानी त पुरा बिमार भयो, this is happening, or maybe this one needs medical attention. Or the mothers will try to hide it, but they will talk to a female health worker, isn't it? Asha worker सँग they might confide, मेरो छोरीलाई यस्तो भयो, कसो गर्नु. So you must catch hold of your Asha worker. तपाईले you do such a lot of hard work, birth certificate निकाल्नु हुन्छ, doctor who signed it, or the register of births and deaths, त्यति बेलाको who's the register of births and deaths, Dentham PHC अरे, Kaluk PHC अरे, you will list them as witnesses. But often as a court, the challenge that we find is that when we are examining the doctor, register, तपाईँ register हुनुहुन्छ? Yes. Births and deaths? Yes. Do you recognize this birth certificate? Yes, but I was not the registrar in such and such year. In 2021, I was actually posted somewhere else, not the issuing authority, not the person who signed the birth certificate. So try and trace the one who issued the birth certificate, or who was the registrar of births and death at the time of the child's birth. What is reflected in the birth certificate? त्यति बेला को थियो, उहाँ त अब कहाँ गयो? That is part of your investigation. Where is he posted now? List him as a witness. If he is not traceable at all, write in your charge sheet, that person is not available. Now he's gone out to study. Doctors are, many of them go out, no? But the present births and register, births and death registrar is such and such, and he's familiar with his signature now. Familiar with his signature. The registrar has to say, I'm familiar, I know his signature, we work together. I can prove his signature. That is another means of proving his signature. Alright? Now, for determination of age, Supreme Court they have laid down in various law cases they have laid down how you can prove it. Juvenile Justice Act, I think you have section 19. There are section 3419, I don't know, where determination of age. You can look up that section also in Juvenile Justice Act. It says determination of age. How? Different stages. Son, you can do it either through birth certificate. You can you get me the Juvenile Justice Act? You can do it through the birth register, whatever different means, you know, parents, whatever. But the Honorable High Court of Sikkim also I'll give you the rulings later, alright? It was there in my PPT, but I don't know where they placed the pen, right? They have discussed many of these cases, and Honorable Bandakarim, I would request, I used to please read the orders of the Honorable High Court in POCSO cases nowadays, and these are cases that even in the Supreme Court they are being upheld, and Sikkim is emerging as one of the states where a lot of cases regarding POCSO is being determined and heard, and laws are being laid down more than other states. So it's a very good thing for you all, because we can derive so much from that, no? So there are a few judgments which I will give you later. This is laid down how to determine age. First it says, I think it's Anish Rai. Parents are the best witnesses, but of course it must be supported by some form of documentary evidence which is reliable, होइन? So there you have your birth certificate. If the parents ले भनेको age र birth certificate को age match गर्यो भने your age is determined. Now supposing parents don't know, then you will turn next to the school certificate, because at the time admission गर्दाखेरि they will always give the age, isn't it? They will give the age. Now here again, तपाईहरुले as investigating officers, you get the principal, you get the register, होइन? तपाईहरुले you bring everything. But again, like the registrar births, the principal will say, this is the birth register? Yes. And where is the name of the child? Oh, at serial number so and so. Where, so did you, were you there when the child was admitted? No. Why? I was not posted there, I was posted somewhere else at the time. Now here is another area where तपाईले investigation गर्नु लागि find out who was the principal at the time. Get that principal, not the principal, present principal of that school. He may issue the certificate saying, yes, in the school register, the date of birth is such and such. You can list him as a witness saying, I certify the date. But more important than that, the law says that, about for example, this is the school admission register. It's a public document, or birth register, it's a public document. It can be a piece of evidence under the Evidence Act. But here it says, CJI, Chandrachud, supposing, okay, here's my handwriting. I've said that state of Rajasthan versus such and such. This is the content. Now this, for example, say is the name of the child, year of birth, who was present, parent, guardian, you know. This content has to be proved. This content. This is admissible. It's an exhibit. It can be exhibited. My exhibit A in the court mark doesn't prove this. You've just said that this is a public document. Now to prove this, you have to prove it in accordance to the Evidence Act. Evidence Act with various sections, that is for the court to determine how. But basically, you have to prove this. Now how do you as investigating an officer make sure that you can prove this? How? This is my handwriting. I'm the best witness to prove this. I have written it. Now I have written State of Rajasthan versus Tarun Vaishnav. Where did I get it? Source. No, I got it from such and such. So being the person entering in the register, the person who is writing this will be the dealing assistant for register births. You have a person called the dealing assistant in every hospital, whose duty is just to enter births. He is a very good witness, the dealing assistant. And some of the dealing assistants have retired. Of this, we have come to learn because evidence we have tried to draw it out from the doctors and from the registrars. Who was the person who wrote this? Oh, at that time there was a dealing assistant. There's a person who has done a lot of those, but he's retired now. But we've called him. Our PP 319 application, we've examined them. That's how we have managed to prove births, date of births. So we call the dealing assistant. Or if you're not able to find the dealing assistant, who was the person at the time? Or who was the ASHA worker? Or who was the source? Main thing is to prove the source of this information. If it says guardian, then father, mother, or उनीहरू त्यति बेला को आफ्नो मान्छे कोही हुन्छ हैन, find out who has signed. एकजनाको सिग्नेचर त हुन्छ त्यहाँ, there's a column. Investigation ma, find out who signed this. Get that person, because that person has first hand knowledge of the birth. हो म त्यहाँ थियो यो हस्पिटलमा जन्मेको, मैले दियो, मैले अफिसलाई उसको डिटेल दिएको. Done. Determination of age airtight. Likewise, many of the dealing assistants will say, oh, I wrote this because मलाई चाहिँ खबर कसले दियो, आशा वर्करले दियो. हस्पिटलमा जन्मियो, it is their duty to report, tell the office. आज यतिवटा बर्थ भयो हस्पिटलमा, then they will write. So the source of the information. So then your date of birth is proved beyond reasonable doubt. Underline, beyond reasonable doubt. No. So if the parents say that, oh, she was born in 86 or she was born in 2022, and if your birth certificate says 2022 and give the details, the date of birth is proved. Isn't it? But just producing your register, just producing your birth certificate is not sufficient. It may be admissible as a public document, but the contents are not proved. Birth certificate ma pani doctor might sign it. Doctor does not know the date of birth. Nani त्यो दिन जन्मे कि जन्मेन. He has just signed it. So who filled up the birth certificate? Again, it might be the dealing assistant. So you have to find out birth certificate त पाउनु भयो तपाईले. त्यो हस्पिटलमा त्यति बेला that year, who was the person responsible for filling in these birth certificates? List him as a witness. Because this person will say कि yes, your handwriting मेरो, मैले भरेको यो date of birth. Because त्यति बेला that parent came and told me. Parent said, hospitalमा यति तारिक जन्मियो, I have signed it. I have entered the details and I placed it before the registrar. Dr. Sabले सही गरेको. So the contents are proved beyond reasonable doubt. So these are the ways and means how you can prove your date of birth through documents. अब document चाहिँ छैन अरे. Sometimes you have हैन कतिवटा केसेसमा there is no document. birth certificate बनाएन. नानी त स्कुलै गएन. School गयो भए पनि went to school in West Bengal, went to school बिचारा आयो, was all over, cannot find. त्यो स्कुल त बन्द भइसक्यो. प्राइमेरी स्कुल थियो, के भन्छ मोन्टेसरी स्कुल, त्यो के भन्छ सानो केटाकेटीहरु स्कुल थियो, त्यो त बन्द भइसक्यो. No record. What will you do? So the last option is ossification test. Yes, ossification test. No, it will give you an approximate age. No, not the exact age, but the approximate age. Okay. Now that is your last resort, right? But how to prove your ossification test? Yes. But what happens is, in cases that we have conducted, sometimes again same old story. X-ray report, yes, yes. Were you the radiologist? No. Radiologist त रिटायर भएर कहिले सक्यो? बिचारा हाम्रो एउटै radiologist डाक्टर गिरी हुनुहुन्थ्यो हैन? Now he is not there. Many of the reports are like that. So make sure that you do a lot of hard work. I know you make a lot of effort to list all the witnesses, but try to get the right witness, because it's a wasted effort now. It's a waste of time. And त्यो बेकारमा त्यो witness को list भर्नु मात्रै हो. If you get the right witnesses, you don't even need more than 5 witnesses in your case. Having a list of 30 witnesses and who are of no importance, and having a list of 6 witnesses, you have your complainant, you have the victim, you have your IO, you have the medical, you have one independent witness, more than enough, and one person to prove your date of birth details, more than enough. You examine your few witnesses, but get the right witness, get the right information. You don't have to go and examine the lay गाउँ हस्पिटलको सबैजना स्कुलको दुनियाँभरको you don't have to do all that. You get the right people, your investigation will be excellent. Just get these few people, but get the right people. I always say get the right people. And another thing, just to let you all know, in the courts, we find list of witnesses, but till down there, the accused is also listed as a witness sometimes. Many cases we found. Askal say it is, I'm happy to say that nowadays it's not so frequent, but earlier it used to happen. Why? Why does it happen, you tell me?
Ma'am, because we take the record the statement of accused as well.
Exactly. You're not paying attention, no? 161 एक थाक छ यसले नम्बर यसको नाम लेखेर नम्बर 2 मा यो छ नम्बर 3 मा यो छ बीचमा accused को पनि भयो हैन and the amazing part is that charge sheet we do 90 days 60 days whatever ready भयो then what happens it passes through every table we find courts are always noting तपाईको सबै superior officers को त्यहाँबाट सबैको first page is full of signatures हैन तपाईको सबैको yes कोर्टमा आउँछ so then we see were they not interested to see who are the witnesses the केसमा कोले कस्तो बयान दिएछ ठीक भयो कि भएन accused is there now what he will appear against himself so these are small details, no doubt. I fully understand the difficulties of I. You are very overworked. I know every police station has manpower problem. But these are little things which will reflect on your profession. You know, hard work गर्नुहोस् हैन अब त्यो 90 days 60 days मा तर त्यो एक line त्यो accused को नाम लेख्दा what is the first impression you get? Even you all are laughing when I tell you, isn't it? हैन तपाईहरु आफैमा हाँस्नुहुन्छ हो के भन्छ अब it dilutes all your hard work no it will look like you conducted the case very lightly or you did not give it enough time or you were very careless negligent and these are all the things that defense will say look I don't think he did not apply his mind at all. Accused को नाम त यहाँ लिस्टमा हालेको थियो पहिला. These are all things that is generally to give the impression that the investigation is faulty, no? Whereas we know, the courts know you have worked hard. And the main purpose is that we have to try and do justice to the victim and saँच्चै नै अब crime commit भएको sexual offense भएको हो भने चाहिँ it is our duty to all sit together and make sure that justice is done to the victim. So these are the main things. Now director sahab तपाईं आउनु भयो भने चाहिँ then we can address some challenges and I think we will be ready to that is more or less if there are any questions or if I'm sorry my PPT is I don't know I have to look for the right but if there are any questions and challenges something, we'll try to address it. I'll give you the judgments later. No? We'll try. It is not that we will have all the answers to your questions because these are challenges. Like I said, POCSO is such an act that even the Supreme Court is grappling with these, they call it grey areas. No? It's a new act. No? There are certain areas where even the courts are finding difficulties, police is finding difficulties. Supreme Court, somehow they don't have an answer. But still we will try our best to address your challenge, difficulties.
Ma'am, with regard to school admission, ma'am, with regard to school admission register, initial school admission register, I have a query. मेरो केसमा के भएको थियो भन्दा चाहिँ ma'am, the victim was initially admitted to ICDS.
One request. Do not discuss pending cases in case
No,
I'm
no,
hearing
no,
the matter.
pending
No,
cases.
okay.
It was done.
We are not allowed to.
I'm just उसमें के बात है the victim was initially admitted to ICDS and from class 1 she was admitted to some primary school like that. And when I when I started my investigation, I initially went to the school where she was educated for the first time. That was primary school, and I submitted the admission register, the extract of the admission register before the court. But later on, I was asked to produce the initial admission register that was of ICTS, and usually in ICTS they don't like preserve the records. So that was a problem I faced.
Actually, I don't know if you all have heard the case of Madhav versus Union of India. No? Madhav versus Union of India. That was the first case of the Supreme Court where they said how to determine the age. This was a problem, from the very beginning. So they have said that when they talked about the school, they said the school first attended by the victim, right? But they have said not nursery school. So ICTS ko khasma chahi record is not the relevant record. It is the first school attended by the child, means not the nursery school, but from class 1. Because then that particular school will start maintaining the record, no? And another thing, if your child has appeared for a board exam, sometimes they are class 10 pass garisakeko bhन्छ हैन, sometimes म 12 मा appear गर्दै थियो हो, sometimes the child is in class 11. If she has appeared in a board examination, that is your best school certificate, because that is the time they will give the date of birth. So even Madhav says the board school, what was it? Madhav was
State of mind.
Sorry, Madhav was the state of Maharashtra. I'll give you the thing later. त्यसमा भनेको छ the school admission register, then the panchayat or के भन्छ GMC को register, or last ma ossification. So त्यसमा चाहिँ actually ICDS को record हैन. It is the it specifically says not nursery. From class 1 upwards you can take, because that is the point of time from where the school record actually starts getting maintained, no? But of course there are schools which start from nursery. But there are many, like in your case, many where they go to nursery somewhere else and then class 1 the regular school. But again I stress, if they have appeared for a board exam, then use the board examination co result. Date of birth is clearly given there. So if you get the parents and your board examination co result, nobody is going to question the authenticity of a board, your ICSE or CBSE result. That result is a board result. So that is an unimpeachable document which will support the age given by the parents. So even a High Court says that is sufficient if it's supported by an unimpeachable document.
We don't have to authenticate that mark sheet for board exam.
That you can list here you can list the principal who was there at the time, who can say that so and so passed out from my school in this year, and this is her result issued by the board. Board ko, you don't have to make the board ko issuing authority or witness. You don't have to make them. You can make the principal. Principal can prove that yes, this is the mark sheet received by us. This is the child's mark sheet. Child was in my school. Because the parents will say that the child's date of birth is such and such. Best parents, if the parents are able to give the date of birth, get it down in their 161. And when you are examining these witnesses, you must impress upon them that this is what you will have to say in court to prove your case. Not tutoring. At the time of investigation, before the examination in court, don't go anywhere near them, right? Otherwise your witness will again say, oh, anything else? Okay, challenges. Now challenges, the investigating officers or challenges faced by you.
Ma'am, in case of Anama, most of the time प्यारेन्ट्ससँग आउँछ नानी बेस्ट चाहिँ के हुन्छ भने आइदर नानीकोबाट एफआइआर लिनु ठिक हुन्छ कि त प्यारेन्ट्सकोबाट किनभने कतिपल्ट चाहिँ प्यारेन्ट्सले रिटर्न ल्याएर आउँछ अघिल्लो जुन चाहिँ रिन्युवल गरेर अन्त उनीहरूले ल्याएको त्यो एफआइआर पनि हामी रिटर्न छ भने चाहिँ उनीहरूले रिन्युवल गरेर फेरि एडिट गर्न
ठिकै छ, you can accept that because that's the written FIR, no, produced by them. तर you must read it out to them and say तपाईले यहाँ यस्तो लेख्नु भएको रहेछ है, ठिकै हो, they will say हो. न धेरैचोटि लेखेर ल्याउने रिपोर्ट चाहिँ के हुन्छ भने उनीहरू आफै लेख्दैन होइन, बिचरा कतिजना चाहिँ गाउँमा को अलिक लेखा परे हुने या पञ्चायत, you will ask them to prepare the report, बिचरा त्यो बोकेर आउँछ. So no problem, you read it out to them. तपाईले रिपोर्ट ल्याउनु भएको रहेछ, यहाँ यस्तो लेखेको रहेछ, ठिकै हो, they will say okay, ठिकै हो, होइन. So then you ask them, did you write it yourself? If they've written it themselves, fine. If they have not written it themselves, they will say, Panchayat ya gaon ko bhai or whoever, होइन, list that person as a witness. Very important because that is the scribe of your FIR. You have to list that person because the complainant, being a ordinary villager, will not know the contents at the time उसलाई examine गर्दाखेरि यो तपाईले लेख्नु भएको हो भने हैन मैले लेखेन, यहाँ के लेखेछ थाहा छ, थाहा छैन, कोले लेख्यो, दिल चाहिँ पञ्चायत या उ तल्लोपट्टिको महिलाले या कोले, होइन. So you bring that person, and when they examine them in court, people will say, did you write that? You will say yes. So people will say, how did you know this? Then you will say, the mother told me, the father told me, as per their dictation. And that witness will have said, मैले फाल्ना भाइलाई भनेको थिएँ, उसले मैले भनेको अनुसारले लेख्यो, तर यहाँ के लेखेछ मलाई थाहा छैन, तर मैले उसलाई यो लेखिदिनु भनेको थियो. So that is how you prove that FIR.
त्यो एफआइआर चाहिँ हामीले अगर नानीलाई अब
Then you record the statement of the victim, no? And to do that, you have to follow procedure in the child-friendly room, or you don't do it in the thana. Do it in the child's home, or if the child doesn't have a home, she has to be taken out to a place of safety, then in the children's home, observation home, wherever. So that even at the time of your cross-examination, it will come out that, no, I did not examine the child in the thana. Complainant, I followed the POCSO rules, and I made sure that I examined the child in a place of safety or a child-friendly place. You will have followed the rules. You know?
Yes.
Anything to add?
Well, just what I am to add, with permission of Honorable Director, we are only this reading POCSO Act while dealing POCSO cases. Because POCSO case को चाहिँ the stakeholder guru हुँदैन. We have to rely JJ Act. त्यसकारणले POCSO Act र JJ Act लाई सँगै लगेर जानुपर्छ तपाईहरुले. किनभने जब मान्छे FIR भइसकेपछि POCSO Act मा त केही पनि छैन, stakeholder कोले के गर्ने. यो चाहिँ न्यूट्रल जेन्डर एक्ट हो. त्यसकारणले गर्दा JJ Act मा तपाईले सहारा लिनुपर्छ. यदि POCSO लाई बचाइराख्ने हो भने फ्यात्तै फ्याँकिराख्यो. तपाईले एफआईआर गरेपछि फ्यात्तै फ्याँकिराख्छ, किनभने POCSO मा त केही छैन, थाहै छैन. त्यसकारणले गर्दा POCSO र JJ Act चाहिँ सँगसँगै पढ्नुपर्छ. यदि तपाईले if you want to succeed, if you want to prove POCSO case before the court, JJ Act लाई पढ्नै पर्छ. किनभने POCSO ले नै भन्छ हाम्रो जति पनि सेना मेनाहरु चाहिँ तपाईको JJ Act मा छ है, तपाईले त्यहाँ रिलाइ गर्नु भनेको छ. नम्बर 2, जस्तै कसरी रिलाइ गर्ने. फर एक्जाम्पल डिस्ट्रिक्ट चाइल्ड प्रोटेक्सन अफिसर छ, अघि आयो इन्टरप्रेटर को बनाउने, सपोर्ट पर्सन कोले बनाउने, एडुकेटर कोले बनाउने. इट इज द टास्क अफ DCPO. DCP has to prepare all this list, and DCP has to pay the remuneration under section 105 of JJ Act. यहाँ छ है सर हाम्रो इन्टरप्रेटर. आयोलाई कहाँ थाहा छ त्यस्तो छैन. Until and unless you know the provision of JJ Act. JJ Act पढ्नुपर्छ. अनि फेरि के छ, हामीले IPC पढ्छौं, POCSO पढ्छौं, CRP पढ्छौं, इन्डियन एभिडेन्स एक्ट कसैले थाहा छैन. इन्डियन एभिडेन्स एक्ट चाहिँ लास्टमा कोर्टमा गएर तपाईको केस टिक्ने नै त्यो हो. इन्डियन इभिडेन्स पढेन भने केही छैन। जस्तै फेरि आइओ अफ द केसले के गर्नुपर्छ, एक्सन प्लान बनाउनु पर्यो। हामी चाहिँ के छ घरमा, फर इक्जाम्पल दिन्छु तपाईँ, इफ यु डोन्ट माइन्ड, के हुन्छ भनेदेखिले चाहिँ हामीले घर बनाउँदाखेरि 9 पोस्टको थाल्छ, पैसा हुँदै गएपछि 12 पोस्ट 29 पोस्ट हुन्छ। त्यो बनाउने मान्छेलाई थाहा छ कि यो घर चाहिँ राइट फ्रम द डेमा टोटली यति भएको मेरो दिमागमा थिएन, किनभने हामी पैसा हुँदै पछि जोड्छौँ। त्यस्तो हुनु हुँदैन, किनभने आइओलाई थाहा छ यो केस कसरी भयो। त्यसै कारण राइट फ्रम द डे वानमा एक्सन प्लान बनाउनु पर्यो। यो कति दिनमा केस सक्ने र कोले के प्रुभ गर्छ, लास्टमा अल्टिमेटली विदिन द प्यारामिटर अफ इन्डियन इभिडेन्स एक्टमा चाहिँ यो कुन चाहिँ मान्छे गएर बोल्छ र यो बोलेको चिज चाहिँ इन्डियन इभिडेन्स एक्टको धारा नम्बर कतिमा बस्छ, कहीँ पनि फेल हुँदैन। तपाईँको टिपे एउटालाई लु जाउँ न यहाँ माथि एउटा गवाई बनाइदियो भन्यो, त्यो गवाई भन्ने मान्छे जिन्दगीमा तपाईँले जस्तो प्रकारको 161 स्टेटमा लेख्छ, जिन्दगीमा कहिले बोलेको हुँदैन उसले। बोलेको छ, मैले जिन्दगीमा बोलेकै छैन यस्तो लेखेको छ, आइओले लेखेको छ, आई डोन्ट नो द कन्टेन्ट्स, हो कि उसको भाषामा लेख्नुपर्छ। सारा सिक्किमको आयोगको चार्जसिट हेरेर लेख्यो भने, आज पढ्यो भने त्यही भाषा छ जो विटनेसले जिन्दगीमा कहिले पनि बोलेको छैन। दताउँछ त्यहाँदेखि कोर्टमा, काम छ। हेर्नुहोस् फर्स्टमा चाहिँ तपाईँहरू पो एक्सपिरियन्स छ त, हामीहरू पो एक्सपिरियन्स छ त कोर्टसँग। उनीहरू त कोर्टमा जब सम्म जान्छ राति सोध्नु छोड्छ, बेलुका यति साह्रो डराउँछ, त्यहाँ क्रस एक्जामिनेसन त कुरै आउँदैन। त्यस कारणले गर्दाखेरि नाउ द ल्याङ्ग्वेज, वाट एभर ल्याङ्ग्वेज दे आर कम्फर्टेबल, त्यसमा रेकर्ड गर्नुपर्छ र मैले भने जे एक्ट गर्नुपर्छ। अनि अर्को कुरा तपाईँको रुलमै छ, भिक्टिम आयो भने थानामा के गर्नु, प्यारेन्ट्ससँग आयो भने के गर्नु, बर्थ सर्टिफिकेट आएको छैन भने जे एक्टमै सबै छ। तपाईँले पढ्नुहोस् न जे एक्ट, जे एक्ट पढ्नु भएको छैन भने पक्सो एक्टको इन्भेस्टिगेसन गर्नु चाहिँ हाफ हार्टेड हुन्छ, हुँदैन। र अरू पनि तपाईँहरूको के क्वेरी छ भने सब परमिसन अफ लर्निङ रिसोर्स पर्सन हामी सेयर गरौँ।
Determination of the child, age of the child, procedure is given there, Rule 12. It's the Chinese section 94. JJ Act, you must read it along with JJ Act. Now, JJ Act ko more than the act in the rules, JJ Act also is accompanied with rules like the POCSO. Your rules ma chai all the duties of the stakeholders, CWC, JJ board, and police unit, what is it? SJPU. SJPU le ke garnu parne ho, the rules specifically, you can look at the act, so just look at the act, look at the rules of JJ Act and POCSO rules and act. If you have these as your handbook, you will have no problem. So you will be able to follow step by step the procedure. Because if you are at a loss how to determine the age, procedure JJ Act they have given it to you, and Rule 12. Things that you can bear in mind. Anything else?
हस्पिटल गएर चेक गर्दा चाहिँ प्रेग्नेन्टको पोजिटिभ केस रिपोर्ट हुन्छ। देन आफ्टर चाहिँ त्यहाँदेखि जो मेडिकल अफिसर हुन्छ उनीहरूले चाहिँ कल बुक इन्टिमेसन गराउँछ। त्यही कल बुक इन्टिमेसनलाई हामीले एफआइआर बनाउनुहुन्छ।
Yes, because that is your first information report, no? What is FIR? The first report you get about the case. So on that basis you will register the case.
That will be your FIR. Victim चाहिँ FIR भएको छैन, तपाईलाई सबैले थाहा छ। FIR नभइकन victim examine गर्नु पाउँदैन भनेपछि डाक्टरलाई केस लाग्छ, किनभने सेभ गर्नु पर्यो उसको लाइफ। Then doctor will report, section 19 हेर्नुहोस्, doctor will report to I of the case and that will be an FIR. यसमा बनाउने कुरा के पनि छैन, जे छ त्यस्तै प्लेस गर्नुहोस्। आइयो साबुरले चाहिँ केस राम्रो बनाउने, लक्ष्मी प्रसाद देवकोटाले भन्नुहुन्छ नि, राम्रो बनाउने मतिले कला बिग्रिन्छ भन्छ नि, त्यसलाई चाहिँ राम्रो बनाउने आफ्नो मेरो केस प्रुफ गर्छु जस्तो छ नेचुरली ठक 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 राख्नुहोस् विदिन द प्यारामिटर अफ द ल। केस आफै प्रुभ भएछ
And parameter of the law भन्नुहुन्छ नि, that is your rules.
फेस गर्छ भनेको when it comes to, because like you said, the most important thing is age when it comes to POCSO Act. So usually के हुन्छ भन्दाखेरि चाहिँ if the victim is from out of our state, अनि त्यतिखेर चाहिँ इनिसियली अब कतिवटा उनीहरूको बर्थ सर्टिफिकेट्सहरू पनि बाहिर बनाएको हुन्छ. फर एन इक्जाम्पल, इन माई केस देयर वाज अ भिक्टिम फ्रम मणिपुर. सो इनिसियल उसको स्कुल पनि त्यहीँ गएको रहेछ. इनिसियली फर्स्ट स्कुल पनि त्यहाँ, बट वेन आई वेन्ट देयर त्यो स्कुल छैन अहिले.
This is what I was saying, no, त्यो स्कुलै उड्छ.
त्यो केही छैन त्यहाँ. हामीले के गर्नु, आई मेन्सन एभ्रिथिङ इन द चार्जसिट, बट द थिङ इज अब त्यसमा पनि डिफेन्स विल गेट द पोइन्ट के द्याट अब यस्तो छैन भनेर. अर्को कुरा चाहिँ के हुन्छ,
So you had ossification as your last.
आई एम कमिङ टु द्याट.
Okay.
Ossificationमा पनि म्याम वाट ह्यापन्स इज borderline केसेस हुन्छ म्याम. जस्तै फर एन एक्जाम्पल भिक्टिम इज 16-17 years old. ओसिफिकेसनमा पनि त्यो रिपोर्टमा दिँदाखेरि इन बिट्विन यस्तो ग्याप दिएको हुन्छ म्याम. लाइक फर एन 17
Margin up and down in both sides.
So त्यसमा borderline केसेसमा पनि we are facing a problem कि त्यो एज.
Now, यस्तो छ, borderline cases, ossification test is that is why it is the last resort, because you are not sure of the age. And then the law says that, okay, because it cannot be specific, no? So you have to have margins on both the lower end and the higher end. त्यस्तो हुँदाखेरि चाहिँ, now the law is that benefit must be given to the accused. Now here our hands are tied. Your hands are tied, our hands are tied, because the law says, अब कानुनले जे भन्यो, we are followers of the law, isn't it? We have to follow that. So then, although you know, I know, probably अब त्यो भएको offense, but if the law gives him that benefit, we have to give him that benefit. Because there's no other way of proving the age. And the last resort is the ossification test, but त्यसमा चाहिँ अब we have to take the higher side. And त्यो higher side ma, if it is a chance that the girl is not a minor, then we have to accept that. And that is the law.
तपाईँको you are confusing one thing. Beyond law, that is your unsuccessful effort. You are misleading the court. Therefore, फर्स्टमा के हुन्छ, ओसिफिकेसन टेस्टमा चाहिँ तपाईँले लिएर आउँछ मेरो कोर्टमा के ओसिफिकेसन टेस्ट यो भित्र बुद्धि के छ थाहा छैन आयोलाई. सो यु हेभ टु रिड दि मेडिकल जुरिस्प्रुडेन्स एन्ड टक विथ हेल्दी टक विथ डक्टर. कसरी प्रुभ गर्नु तपाईँले, बिकज आई हेभ टु एन्सर बिफोर द कोर्ट. यु विल कम एन्ड गो. आई हेभ टु प्रुभ कसरी भयो यो ओसिफिकेसन टेस्ट, यसको कहाँ छ यसको फिल्महरू, अन्त के छ ल यसमा लिएर लगायो टक्कै छैन भित्र बुद्धि. त्यस कारणले गर्दाखेरि ओसिफिकेसन टेस्ट लले चाहिँ जहाँ बेनिफिट दिँदैछ प्रोभिजन फर ल, यु हेभ टु स्ट्रेच्युरी प्रोभिजन. इभन सुप्रिम कोर्ट हेज टु फलो, नट ओन्ली इन द केस अफ आइयु ओन्ली. देयर इज नो डकुमेन्ट, यु आर गोइङ टेकिङ सेल्टर अफ ओसिफिकेसन टेस्ट. वाट ओसिफिकेसन टेस्ट यु हेभ टु सबमिट द्याट. तपाईँको सेक्सन 2 मै गइहाल्यो केस. सो देयरफोर इफ सेक्सन 2 मा चाहिँ यो माइनर हुँदै छैन भनेदेखिलाई चाहिँ यु हेभ टु टेक सेल्टर अफ आइपिसी. यु हेभ टु प्रिपेयर चार्जसिट इन द्याट पर्टिकुलर वे. गेटिङ माई पोइन्ट. यु हेभ टु पनिस, यु हेभ टु प्रोभाइड, यु हेभ टु गिभ जस्टिस टु द भिक्टिम. If you come to know after going through the ossification trace report, this case is not coming under POCSO Act, then you have to take shelter of IPC. How you will prove? You have to prepare the evidence, then file the charge sheet. अब आइपिसीमा पनि छैन, पक्सोमा पनि छैन भनेदेखिलाई चाहिँ यु क्यानट म्यानिपुलेट. यो होइन पिपीहरूको पनि त्यस्तै कोसिस हुन्छ, कोर्टमा केस प्रुभ गर्नै पर्छ, ल डिपार्टमेन्टले कराउँछ, प्रस्क्युट त्यो होइन नि, के छ फ्याक्ट त्यो पो प्लेस गर्नुपर्छ त. एन्ड देन यु हेभ टु टेक, you have to consider the case from the side of the accused also. He is also innocent sometimes. If benefit is now going in his favor, how you can restrict? आइयो को केस प्रुभ गर्नै पर्छ भन्ने छैन नि. कसरी प्रुभ गर्छ तपाईँले बियोन्ड ल? लले जे भन्छ त्यही प्रुभ गर्नुपर्छ. कोर्ट विल सी वेदर आइयो हेज विथ मेन्टेनिङ इन्टिग्रिटी सिन्सियरली मेक एन एफर्ट एन्ड फाइल द चार्ज सिट अर नट. त्यो मात्रै हेर्छ, अरू केही हेर्दैन. अनि कोर्टले भन्छ त्यसै छोड्यो भन्छ.
सरले भन्नुभएको जस्तो अब माइट नट बी अ माइनर, अब यु क्यानट प्रुभ सी इज अ माइनर होइन, बट एन अफेन्स हेज बिन कमिटेड. योर case might not stand under POCSO, but it can, the minute is a major, but if you prove that the sexual assault was without consent, then 376. Because 375 ले के भन्छ? Without her consent, if it was forceful, if she was duped, or if she was under coercion, or if she was administered any substance that made her incapable of giving consent. So it can fall under any one of these categories under 375. So the case can be convicted under 376 also, not necessarily that it has to be under POCSO. अब minor होइन case fail भयो भनेर त. Not necessarily, if indeed there is rape. But if it's consensual, then that is again a different thing. So that is why if you read our judgments, you will find that number one issue for determination by this court is age. We discuss how age is proved or not proved. Look, age proved binary, we will say. Fine, girl is a major. Second question, automatically what will be the second question? Was it consensual? Did the prosecution prove it was rape or forceful sexual assault? Here we will see whether the victim said it was consensual or not. Here we will see whether the victim has said, yes, I was administered alcohol and त्यति बेला मलाई याद भएन मलाई जबरजस्ती गरेछ या मलाई जबरजस्ती गर्यो, I was fighting him but there was no one around, I screamed and shouted. The medical evidence. So that option is always there if it is a borderline case. Now if it is 12 years, 13 years, 10 years, so there is no question because it totally aggravated hunsa and then the child itself. And another thing I find is sometimes it's very difficult to assess the age of the child, but physically herdakiri pani, it is so obvious that the child, our child of 5 cannot be considered a borderline case. Child is only what, 3 feet? You know? There are some absurd cases also where they've said that, oh, we could not prove the age of the child because there is no document, no whatever. But a duty is cast on you and the court also to make an observation. It is noted that, I always said, if it is such, then I will say that child is only about 3 feet. Even to the bare naked eye also, it is evident that if I look at this, I know that it's a microphone. I will not say that this is a black rose, you know. So even to the naked eye, the child is a child. There are situations like that also. So there are certain things, duty is cast on you and the court also to sometimes little bit think out of the box and try to, you know, prove the age of the child. Anything else? Any conclusion you?
164 or 161. किनभने 164 मा अगर एउटा भिक्टिमलाई पास्ट 3-4 डेजको लागि कहीँ लगेर के भएको थियो भने उसले कतिवटा डेट मिस गरिरहेको हुन्छ। सो 161 मा आयोगलाई त भनिन्छ यो डेटमा यहाँ गएको थियो, यस्तो भएको थियो, यो दिनमा फेरि उसले अर्को ठाउँ लग्यो, मलाई यस्तो गर्यो। त्यो 161 मा हामी रिलाइ गरिरहेको हुन्छ। बट वेन इट कम्स टु 164 त्यहाँ हेर्दाखेरि जज फर्डिनान्डको छेउमा चाहिँ उनीहरूले कतिवटा डेट मिस गरिरहेको हुन्छ। सो हामीलाई लाग्छ कि ला 161 मा रिलाइ गर्यो भने 164 मा उसले फेरि अर्कै डेट दिइरहेको छ। त्यसमा अलिकति नै
तपाईँको 161 स्टेटमेन्टमा संशोधन भएर तपाईँले अडियो भिडियो रेकर्डिङ गर्नु भने चाहिँ अहिलेसम्म मैले देखेको छु नि चार्जसिटमा। 65 को के छ सर्टिफिकेट दिनु? केही पनि छैन नि। जाने छ भने कोर्टमा माग्नुहोस् एउटा कुनै चार्जसिट फाइल गरेछ। अडियो भिडियो रेकर्डिङ गरे हो कि होइन? अडियो भिडियो रेकर्डिङ गर्दाखेरि त उसको तपाईँ अडियो भिडियो रेकर्डिङ त कोर्टले त हेर्छ नि त हो। तर तपाईँले सिधा उहिले इन्फर्मेसन टेक्नोलोजी नजन्मिकन अगाडिको जस्तो चार्जसिट फाइल गर्दैछ नि। सँगसँगै लानुहोस् न इन्फर्मेसन टेक्नोलोजी भन्ने। इन्डियन इभिडेन्स सँगसँगै लानुहोस्, इन्फर्मेसन टेक्नोलोजी सँगसँगै लानुहोस्। त्यस कारण अडियो भिडियो रेकर्डिङ हेरिसकेपछि ठिकै छ देखाइदिनुहोस् उसलाई तपाईँले यो भन्नुभएको छ, तर लाउडली तपाईँले यो भन्नुभएको छ है हेर्नुहोस् भिडियोमा। अनि उसको मनमा आउँछ नि अघि त केटाहरूले धम्की दिएको थियो तर मैले त भनेको छु भिडियोमा आयो साहबले देखाएको छ, यहाँ त पुरा रेकर्ड गरेको रहेछ। उसलाई पनि होस् हुन्छ तर डराएर धम्काएर होइन, उसलाई चाहिँ लाउडली भन्नु पर्यो उहाँको गार्जियनको समयमा। नि तपाईँले चाहिँ यो पोइन्ट भन्नुभएको छ। 164 मा के गर्छ? आयो साहबले एउटा एप्लिकेसन गर्छ कसले ल्याउने इन्टरप्रेटर, कसले ल्याउने हेल्प, त्यो सपोर्ट पर्सन, IU has to submit a requisition to the concerned judicial magistrate saying that this support person may kindly be permitted to sit with victim. नभनिकन आफै आउँछ, जुडिसियल म्याजिस्ट्रेटले रिक्वेजिसन गर्छ, गर्दैन नि. इट इज टास्क अफ द IU अफ द केस टु कम विथ रिक्वेजिसन बिफोर रिकर्डिङ 164 स्टेटमेन्ट अफ द विक्टिम. कोसँग आउने, कोसँग कम्फर्टेबल छ, एडुकेटर छ, इन्टरप्रेटर को छैन, त्यसलाई एडमिट गर्नु पऱ्यो जुडिसियल म्याजिस्ट्रेटले. पहिले अर्डरमा रिफ्लेक्ट गर्नु पऱ्यो, देन दि प्रोसिडिङ विल स्टार्ट. तर के छ भनेदेखिलाई चाहिँ रिक्वेजिसन गर्छ, विथ अल रेस्पेक्ट जुडिसियल म्याजिस्ट्रेट डेट दिन्छ, अनि उसलाई रुम पनि छैन, टाइम पनि छैन. त्यो भिक्टिमलाई भन्नुपर्छ यो दिन तपाईँको रेकर्ड हुन्छ है स्टेटमेन्ट, गार्जेनलाई भन्नुहोस्. त्यस कारणले गर्दाखेरि तपाईँले मनस्थितिमा त्यो कुराहरू राखेर आउनुहोस्. उसलाई थाहा छैन, सट्टै गाडीमा ल्याउँछ, घुर गरेर कुदाएर लान्छ, डक्टर भित्र लगे कुनै कहाँ ठ्याक्कै राख्छ, के हो बेहोस हुन्छ मान्छे. हामीलाई बस कमन हुन्छ त. तपाईँले त्यहाँ एउटा भिक्टिमलाई राम्रो प्रकारले एडुकेटर सपोर्ट पर्सनको लागि छेउमा सुन्नुहोस् न. उसले तपाईँले नसोचेको कुराहरू भन्छ, तपाईँले यस्तो खालको अवस्थामा लगेर राख्यो, म त त्यो त बेहोस भएँ. त्यहाँ के को स्टेटमेन्ट भने भिक्टिम बचाउनु साह्रो पर्छ, त्यहाँ सास फेर्नु साह्रो पर्छ म्याजिस्ट्रेट गरेर, कसरी हुन्छ नि. त्यस कारणले गर्दाखेरि यु हेभ टु सबमिट रिक्वेजिसन, यु हेभ टु रिमाइन्ड टु द भिक्टिम, रेकर्ड थ्रु अडियो भिडियो, फाइल 65B इन्डियन एभिडेन्स एक्ट सर्टिफिकेट 1872, देन you will be 100% sure I will prove this particular case, I will render justice to the victim. अनि कसले भन्ने त्यो कुरा, यो भन्ने समय र हाम्रो लर्नेड रिसोर्स पर्सन तपाईँले कोर्टमा गएर सोध्नु सक्दैन. यही समय हो, तपाईँले एकदम नहिचकिचाइकन के पनि प्रब्लम छ तपाईँले सोध्नुहोस् आज. त्यस कारण सिक्किम जुडिसियल एकाडेमीको ट्रेनिङ सेन्टर, यहाँ ट्रेनिङ पनि नभन्यो, एउटा वर्कसप जस्तो ओरिएन्टेसन प्रोग्राम चाहिँ गरेको. यो तपाईँले खुल्ला रूपले भन्नु पऱ्यो, कोर्टमा गएर सोध्नु सक्दैन. हायर अथोरिटीले सोध्यो भने के हुन्छ थाहा छ, केही जान्दैन, योले व्यथामै दियो केस भन्छ, हो कि होइन. त्यस कारण आज नै तपाईँले सबै कुराहरू क्लियरिफाई गरेर आउनुहोस्. प्रिपेयर दि नोट. आज गएर सबैले फेरि आज ट्रेनिङ गरे, कसैले प्रिपेयर नोट गर्दैन, नोट प्रिपेयर गर्दैन. अस्ति भनेको थियो जस्तो लाग्यो, बिर्सियो भन्यो. त्यस कारणले गर्दाखेरि तपाईँको आजै क्लियरिफाई गर्नुहोस् कतिवटा कुराहरू चाहिँ. मलाई चाहिँ यो प्रब्लम छ.
So while we're listening, जे भएको सबै भनिहाल्छ. So and then like उसलाई हामीले सेल्टरमा पठाउँछ. तर त्यो जुन चाइल्ड केयर सेन्टरबाट उनीहरूलाई 2 दिन या 3 दिनमै विदाउट आएको नलेज छोडिदिइहाल्छ. 164 आउँदा नआउँदा चाहिँ कोही कोही बेला अलिक ढिलो हुन्छ. त्यो 164 मा उसको स्टेटमेन्टै चेन्ज हुन्छ.
See, 1 minute, sorry. I just told you भन्नुभयो नि recording of statement. That time I told you, no, there is specific chapter 6. It's given procedure how to record statement. त्यसमा जस्तो सरले भन्नुभएको जस्तो there is a provision wherever possible the magistrate or the police officer as the case may be shall ensure that the statement of the child is also recorded by audio video electronic means. So although 161 statement say court cannot rely upon it like a 164 statement, it's not substantive evidence. But if you have audio visuals, you know, because it says it must be recorded in this manner, especially if it's a specially able child, you have to record it. Yeah, हाम्रो courtsमा त we do audio video recording. त्यस्तो गर्नुभयो भने चाहिँ it helps you solve problems like this. अब we cannot control circumstances of the child's environment, हैन. चाइल्ड जान्छ, घरमा के सुन्ला, के भन्ला, होममा के सिक्ला, अरू भिक्टिमसँग इन्टरेक्ट गर्दा the statement it has to change. It's normal. If the statements remains the same from the beginning of the sentence to the last, that is also unreliable. It is not humanly possible that your 161 statement and 164 statement and statement before the court will be ditto. It has to change. Then it's a natural, reliable statement.
After the victim leaves child care center, then while recording the statement under 164, the victim itself, like she is hostile, she changes her entire statement.
No, then she can be confronted with her.
Just I want to clarify for your just reference in future. के हुन्छ भन्दाखेरि चाहिँ यो कुराहरू मैले अस्ति उठाएको थिएँ SLSA मा, सिक्किम स्टेट लिगल सर्भिस अथोरिटीमा. हाम्रो माई दिस सुनियर क्लिक वाज अल्सो देयर. के हुँदैछ भन्देखिलाई चाहिँ यो एक्ट इम्प्लिमेन्ट गर्नु जे एक्ट इम्प्लिमेन्ट गर्नु चाहिँ एउटै सेल्टर मुनि सबै स्टेक होल्डरहरू बस्नुपर्छ भनेको थिएँ मैले। किन भन्नुहोस् त, स्पेसियल जुबिनाइल पुलिस युनिट अर्को छ, CWC कुनै कहाँ छ, डिस्ट्रिक्ट चाइल्ड प्रोटेक्सन अफिसर पर बसिरहेको छ, चाइल्ड सेन्टर कुनै कहाँ बसिरहेको छ, IO कुनै कहाँ बसिरहेको छ। There is communication gap. It is the responsibility of Special Juvenile Police Unit to make sure that there is a coordination with IO of the case. CWC को काम हो त्यो, बुझ्नुभयो? र Special Juvenile Police Unit को काम हो to coordinate with IO of the case, make sure there is no any tutor to any one of the witnesses, including the victim. त्यो चाहिँ कोअर्डिनेसन नभएर त्यस्तो भएको। अनि फेरि काउन्सिलिङ रिपोर्ट IO अफ द केसले फाइल गरिदिन्छ है चार्जसिटसँग। Hon'ble High Court of Delhi, even in my judgment when I was a POCSO, Special Judge POCSO Act, I refer in my judgment whatever report के हुन्छ भने के हुन्छ 164 स्टेटमेन्ट IO ले लान्छ, काउन्सिलरलाई देखाउँछ, DCPO लाई, CWC लाई, अनि उनीहरूले सिकाउँछ यस्तो भन्नु है कोर्टमा 164 मा आज तिम्रो छैन यहाँ बाउ IO लाई लिएर आऊ, यहाँ भोलि तिम्रो स्टेटमेन्ट छ माथि कोर्टमा, यहाँ लिएर आऊ, सिकाउँछ। बुझ्नुभयो? नानै सिकाएको काम लाग्छ, नानै काउन्सिलको रिपोर्ट चाहिँ यु आर नट सपोज टु मेक अ पार्ट अफ द चार्ज सिट, and there has to be coordination with the Special Juvenile Police Unit, with IO of the case and the in charge of shelter home, until and unless you complete the investigation and until and unless trial of that particular case is completed. Special Juvenile Police Unit को काम हो shelter home मा के गर्दैछ, स्पेशल जजलाई इन्फर्मेसन गर्ने के हुँदैछ प्रोग्रेस चाहिँ। स्पेशल जज should know what is the condition of the victim after registration of this particular case, and it's duty of the Special Juvenile Police Unit and IO of the case to inform. बुझ्नु भएन? हो यो कोअर्डिनेसन छैन नि, कुनै कहाँ गइराखेको हुन्छ, कसको कुनै कहाँ ए मलाई फोन नगर्नु म DCPO के मेरो काम होइन, IO लाई रेजिस्ट्रेसन गर्नु भन्छ, होइन फेरि DCPO आफै गएर रेजिस्ट्रेसन गरिराखेको हुन्छ केसहरू। त्यो नबुझेर त्यो मेटेरियल हामी दिन्छौँ, तपाईहरु पढ्नुस्। र अहिले चाहिँ फाइदा चाहिँ हाम्रो लर्नेड रिसोर्स पर्सनको प्रेजेन्सलाई चाहिँ उठाउनुस् तपाईहरु। अझै के छ भने अझै आउनु पर्यो 20-30 वटा क्वेरीहरु तपाईहरुको। हजुर
कुरा भन्ने मेरो कलिगले भने सर के हुन्छ भन्दाखेरि युजुअली 164 मा सरी 161 हामीले इनिशियली पाउँछ। 161 मा त एभ्रिथिङ मेन्सन गर्छ, हामी क्वेशनर फर्ममै आजकल त्यो ट्रेडिसनल हामी मेरो साँचो बयान न्यू वाला दिदैन सर, आजकल हामीले एउटा क्वेशनर फर्ममा गर्दैछ सर। र चाहिँ अन्त के हुन्छ भन्दा सर अब एलोपमेन्टको केसेस हुन्छ, कोहीला भागेर गएको हुन्छ। सो हामी चाहिँ 161 मा भागेर गएकोदेखि देखेर उसँग सेक्सुअल एसल्ट भएको छ भने सबै मेन्सन गर्छ हैन सर। बट जब 164 हामी रेकर्ड गर्नु जान्छ उसले खालि त्यो भागेको पोर्सन मात्रै त्यति मात्रै आउँछ कोही बिकज उनीहरूले डल्लै कुरा भन्दैन अब त्यहाँनिर त सायद त्यो एउटा कम्फर्ट हुँदैन होला त्यो 164 एट द टाइम अफ सबमिसन अफ चार्ज सिट चाहिँ बिकज हामी वी रिलाइ अन 164 मोर देन 161 बिकज एभिडेन्स पनि 164 को बेसी हुन्छ।
यस्तो केसमा चाहिँ नि तपाईलाई मेन थिङ लाइक आई टोल्ड यु अघि, यु हेभ टु सी वाज इट कन्सेन्सुअल। अब तपाईले भागेर गयो भने व्हाट गर्ल ran away voluntarily, was she kidnapped, did she go voluntarily? If it's case of eloping, that means they were obviously in a relationship, right? Now if she does not want to prosecute because she has consented somewhere, then you have to do fair investigation. Just because अब parents को pressure ले 161 मा थानामा ल्याउँदाखेरि sometimes it's always because the parents don't want to, they are not के भन्छ consenting to the relationship, हैन? प्यारेन्ट्सहरु अब दे मान्दैन, केटा मन परेन या केटी मन परेन। So त्यसै कारणले it's on the due to the parents pressure that such cases come. अब त्यस्तो हुँदाखेरि चाहिँ the under pressure the girl might give 161 against the boy. But by the time 164 हुँदाखेरि maybe she has realized that the implication of what she has done, if it is consensual, and the consensual मा हो भने चाहिँ like I have already told you what to do, you know. Now if it is not consensual, 164 मा हो भने चाहिँ then that is a different matter. अब 164 मा why did she turn hostile? obviously she was influenced by somebody. If it is such it's a case of sexual assault and she's turned hostile. त्यस्तो नहुनुको लागि चाहिँ अघि सरले भन्नुभएको जस्तो that is why Juvenile Justice Act ma you have SGPU हैन, then you have case worker भनेर. Every child, see, every child who is a victim of POCSO is a child in need of care and protection. It's a child who has to be protected. The child is in need of special care. So you have a case worker. State Bharata, you have a case worker for the child. Your case worker ko duty ho that the child is protected, whether it is in a home, whether it is in her own home, to see that nobody influences the child. It is her duty, his duty. It is also her duty to see that so that she will not change her statement, or she will give a proper statement. She has to bring the child to the court before the 164 to familiarize her with the environment. Like I said, after the police, every person, every adult, no matter whether he is an officer, educated, court बाट summon आयो भने पनि they will now have sleepless nights till the date they have to go to court, हैन. कोर्टमा जानुपर्छ, उनीहरु रातभरि सुत्दैन सुत्ता लागेर. They might not be accused, simple witness, seizure witness, डराउँछ कुरा. Imagine the state of a child, कोर्टमा जानुपर्छ भन्यो भने 100 times more anxiety. मुख खोल्ने हैन एक त कोर्टमा आउने बित्तिकै हैन. So now the act says, the rules say that it is the duty of the case worker कि कोर्टमा लानु अगाडि take them to the visit of the court, familiarize. They don't go into the courtrooms. આજકાલ we have vulnerable witness deposition center. It is child friendly. We make it comfortable, we make it child friendly. त्यहाँ गएर बस पछि तिमी यहाँ आउनु पर्छ ल. यहाँ बयान दिनुपर्छ ल. See, it is like this, घुमाउनु अन्त देखाउनु हो. त्यसो गर्दाखेरि child psychologically is now familiarized. Anything new, even as an adult, हामीलाई अलिकति apprehension हुन्छ हैन. So likewise, child like courtमा चाहिँ familiarize गराउनै पर्छ. They have to. It is the duty of the case worker. And as IO, you tell the case worker. 164 को अगाडि लानु. And पहिला त GMs हरुले they used to do in the chambers 164. Nowadays, I always tell the GMs, use the vulnerable witness center. Use the vulnerable witness center. त्यति बेला पनि they will record. And त्यहाँ they were not, आजकल GMs are also trained. They will not jump immediately into लु के भयो छिटो छिटो भन हैन. You have to give them time. As IO, as the presiding officer of POCSO cases, as the GM recording 164, as the SGPU recording statement, we have to do it with patience. Time dinai पर्छ, otherwise you will not get your statement. You have to give them patience. And like I said, you can use so many other means also while recording statement.
To audio record and video record the statement of the victim. But sir, यसमा के हुन्छ भने चाहिँ we usually use our phone and the certification पनि हामीले आफै दिन्छ. Sir, at the time of job of court मा जब यो evidence produce हुन्छ, we have to produce the primary evidence, I suppose, sir.
The phone.
सुन्नुहोस्, फर्स्टमा तपाईँको कन्फ्युजन के भएको थियो भने अघि तपाईँले भिक्टिमले स्टेटमेन्ट चेन्ज गर्यो भन्दैछ नि. तपाईँले यो कन्सन्ट्रेट फर्स्ट इनिसियली के छ भनेदेखिलाई चाहिँ तपाईँको मेटेरियलै छैन, 5 स्टार बनाउन थाले तपाईँले. यु कन्सन्ट्रेट दि एज अफ भिक्टिम भन्ने केस हेर्नुहोस् न, केस चाहिँ के छ. तपाईँले एज हेरेर रेजिस्ट्रेसन गर्यो होइन. अब अल्टिमेटली यु आर गेटिङ 60 days टाइम, 30 days टाइम टु प्रिपेयर दि चार्जसिट. मसलै बेगरको चार्जसिट हुँदैछ यसमा. तपाईँले कन्सन्ट्रेट गरे पहिले गार्जियनले भनेको थियो यस्तो हराए, बलात्कार गरे, डेट अफ बर्थ सर्टिफिकेटले हो यो माइनर केस त सुरु गर्नु पर्यो अब. तर उसले के भन्दैछ भिक्टिमले, किनभने तपाईँले चार्जसिट बनाएर मसला गरेर पठाउनुहोस्, भिक्टिमले के गर्छ लास्टमा, यो सब बकवास हो. म आफै गएको उसँग, उसलाई रादर आई कॉल्ड हिम एट दिस पर्टिकुलर पोइन्ट एन्ड वी इलोप टुगेदर. देयर वाज नो फोर्सफुल सेक्सुअल एसल्ट. के गर्छ तपाईँले? त्यस कारणले डोन्ट कन्सन्ट्रेट अन एज अफ द भिक्टिम फर्स्ट. यु गो थ्रु दि केस. केस चाहिँ के हो, डकुमेन्ट हुँदैछ नि, केस चाहिँ के भन्दैछ उसले चाहिँ, वास्तविकमा चाहिँ के हो केस चाहिँ. त्यस कारणले गर्दा त लामो समय दिएको त 173 मा यति दिनमा चार्जसिट फाइल गर्नु. आज एउटा केस भएको थियो एकै दिनमा चार्जसिट भयो, एकै दिनमा भएर उहाँ सुप्रिम कोर्टले उहाँलाई उयो पनि गरे, हाइकोर्टले इस्यु पनि गरे समन्सहरू किन यस्तो डिस्पोज गर्यो भनेर। लामो समय दिएको कारण त्यस कारणले गर्दाखेरि वास्तविकमा चाहिँ रियालिटीमा पुग्नु पऱ्यो नि तपाईँ चाहिँ, न कि अरूले भनेको कुरा, फोर्समा भनेको कुरा, डेट अफ बर्थ मात्रै लिएर रेजिस्ट्रेसन गरिहाल्यो। मैले डेट अफ बर्थ लिएँ तर मैले प्रुभ गर्न सक्छु त केस। त्यसै कारणले गर्दाखेरि यु हेभ टु एक्जामिन अल विटनेसेस एक्वाइन्टेड विथ फ्याक्ट एन्ड सर्कमस्टान्सेस इन्क्लुडिङ द भिक्टिम। वास्तविकमा चाहिँ के हो कुरा चाहिँ, तर चाहिँ तपाईँ चाहिँ वास्तविकमा नगएर डाइरेक्ट पक्सो भनेर तपाईँको बर्थ सर्टिफिकेट हेरेर गर्नु। त्यस कारणले गर्दा लामो समय सोध्नुहोस्। देयर इज नो रेस्ट्रिक्सन टु एक्जामिन द भिक्टिम अर एनी विटनेस एज मेनी टाइम्स एज यु वान्ट, इन्क्लुडिङ 164 स्टेटमेन्ट। एकताल भरे हो जजले त मार्छलाई, एकताल भयो कुरा त उल्टा पुल्टा भनेर आएछ, किनभने युल गेट 164 स्टेटमेन्ट कपी विथ द क्याबिनेट नट टु सर्कुलेट टु एनीबडी। इफ यु आर नट सेटिस्फाई यु क्यान अगेन प्रड्युस। कोही बेला भन्दै भन्दैन 161 मा अगेन यु क्यान प्रड्युस। देयर इज नो रेस्ट्रिक्सन, देयर इज नो जजमेन्ट एनी रेस्ट्रिक्सन एनी अथोरिटी सो फार आई नो। त्यस कारणले गर्दाखेरि यु एक्जामिन द भिक्टिम अगेन एन्ड अगेन, कन्फर्म इट भएको हो कि उसको कन्सेन्टको खिलाफ भएको पक्का हो कि होइन। छोडिदिनुहोस् एज माइनर एज साइनर एज, किनभने माइनर एज क्रिमिनल एमेन्डमेन्ट 2013 मा त्यसै कारणले गर्दा पार्लियामेन्टमा पक्सो बनाउँदाखेरि यतामा पनि एमेन्डमेन्ट गरिदिएको छ, त्यहाँ छोड्यो भने यहाँ हाल्नुपर्छ यसलाई भनेर। त्यस कारणले गर्दा तर रियालिटी के हो, साँच्चै एगेन्स्ट द कन्सेन्ट भएको छ हेर्नुहोस् न। त्यस कारणले गर्दाखेरि त्यस कारणले भिक्टिमको माइनर एज मात्रै नहेर्नुहोस्, खासै रियालिटी के हो। एन नम्बर अफ टाइम्स यु एक्जामिन एज पर द कन्भिनियन्स अफ द भिक्टिम। रेसिडेन्समा गर्नुहोस्, सपोर्ट पर्सनल लिएर गर्नुहोस्, आमबाउको छेउमा गर्नुहोस्, के भन्छ खासमा चाहिँ। किनभने उसले बोल्ने हो कोर्टमा, तपाईँले आज त बनाए चार्जसिट उसले बोलिदिँदैन भोलि कोर्टमा, अनि फाटो चार्ज यो त्यसै फसायो आयोले भन्छ, त्यसै अन्नेसरीली मेहनत खत्तम हुन्छ, हो कि होइन। र अरू के छ तपाईँको केही भन्नु छ कि? म त म्याडमको टाइम के
भएर पनि तर त्यसमा त उयो त हुन्छ नि कन्सेन्चुअल सेक्स, त्यसमा त मैले भन्नु छ कन्भिक्सन त हुनुपर्ने।
कन्सेन्सुअल तर यस्तो हुन्छ नि, सपोज सब्स्टान्सिभ इभिडेन्स मेडिकल सर्टिफिकेट छ तर भिक्टिमले सपोर्ट गर्दै छैन। मेडिकल सर्टिफिकेट जस्ट एन ओपिनियन, सेक्सन 45 अफ इन्डियन एभिडेन्स एक्ट 1872 हेर्नुहोस्, यु विल गेट द्याट आइडेन्टिटी ओन्ली डक्टरको। तर सब्स्टान्सिभ इभिडेन्स भिक्टिमले हेल्पै गरेको छैन, तपाईँले मैले त गरेकै छैन भन्दा के हो, भएकै छैन। मेरोमा हुनसक्छ अरूमा के गरेँ अरू, म साइक्लिङ गरेँ होला के गरेँ होला, तर सब्स्टान्सिभ इभिडेन्स चाहिँ भिक्टिम हो। भिक्टिमलाई कोरोबोरेट गर्ने चाहिँ तपाईँको विटनेसको हो, विटनेसले सपोर्ट गर्दै जान्छ, 164 ले सपोर्ट गर्दै जान्छ, डक्टरको डकुमेन्टले सपोर्ट गर्दै जान्छ, तर बेस नै तपाईँको छैन, बेस नै मरिरहेको छ। कसरी
सेक्सुअल असल्ट त भागै हो, किनभने एजको त्यो माइनर भएर आउँछ, तर अब त्यो जुन चाहिँ सबै एभिडेन्स त सबै छ। मैले भनेको जस्तो कन्भिक्सन चाहिँ हुन्छ कि हुँदैन, किनभने
If it's consensual.
yes,
Now this is why, that I told you about the Rajasthan ko case and
but she's way minor, like
below 16 years.
below 16.
Then consent is no consent in the eyes of law. Then we have to go by the law, no, in that case. So if it is section 16 and even below age of 16 and below age of 12, they're aggravated. Aggravated horror, and you look at the age of the accused also. Sometimes he'll be like 40, 30s. Child will be 15, 12. Then there is no question of it being consensual, because sometimes the child like phakara, you can make it consensual. Consent is no consent in the eyes of law. You don't have to write that. That is the court's duty. And whether conviction garnu na garnu, that is the court's duty. Your job is to investigate. Your job is not to convict. Charge sheet ma conviction na garnus. Don't write your charge sheet with the aim of conviction. Prepare your charge sheet on the basis of your findings. That is why you use the word investigation, because the court cannot investigate.
So, ma'am, there we can write that the victim was sexually assaulted by
Obviously, what do you find? I will not say you can write that. You will write what you find during your investigation. What do you find?
But the victim, she is always like 8, 9, 10, 11, 12 years. She's like,
no matter, the victim may say that, but if she's below 12, it's aggravated. No, there is no question. The cases that I'm talking about in the Supreme Court, These are borderline cases where the court has underlined they were in a physical relationship and the girl is above 16 years old and they have consented to get married and they were in a relationship from such and such time. Evidence ma nikliन्छ नि त त्यो. यो अब 16-year-old ले आज consent गर्यो अरे. I'm sorry, supposing the girl is 12 and the accused said no, she consented. The girl also said I consented. It is only on that day because उसले फकायो होला, मिठाई दियो होला, के दियो होला. So that is using inducement, no, inducement. So these are the things. You look at your sections, you will get the words. She was induced, that's not consent. Ula inducement लगायो नि मिठाई दियो सानो नानीलाई, look, come with me, sit on the bed, you open your own pants. Girl will do it herself, child will do it herself. That's not consent, but, you know.
My question was not answered, sir. With regard to, sir, electronic recording of evidence, sir. Sir, and one more thing, sir. Can we submit a requisition under 164 for recording the statement of victim on the electronic?
You don't have to go submit. The rules say you have to. Section 19 POCSO हेर्नुस् त.
को जुन चाहिँ प्रोसिडिङ छ that is under the jurisdiction of magistrate. Magistrate will record. If magistrate took the assistance of audio video, she will also preserve. She will get a copy of that and supply to the IO, and she will submit to the special court, special judge, with seal envelope. She will warn to IO of the case saying that I am handing over this audio video and this 164 statement exclusively for your reference in investigation. You are not supposed to circulate. त्यो चाहिँ उहाँले गर्छ. तर तपाईको रिक्विजिसन लेख्नु पर्यो नि. मैले अघि भने त तपाईलाई के चाहिन्छ रिक्विजिसन लेख्नुस् न. With prior to judicial magistrate, this proceeding may also kindly be captured by the audio video. This proceeding should be supported by the presence of support person. This proceeding should be supported by the interpreter, because I know the nature of the victim. This statement, this proceeding should be in presence of parents of the victim. Requisition में लेख्नुस् न. उहाँले order में लेख्नु पर्छ फेरि. Order में लेखेर त्यहाँदेखि you can proceed to it. अब यस्तो हुन्छ, अहिले चाहिँ कन्फ्युज भयो उहाँको चाहिँ के छ भन्दाखेरि चाहिँ भिक्टिमले चाहिँ कन्सेन्ट दिए पनि नो कन्सेन्ट हुन्छ, द्याट इज इस्टाब्लिस ल. तर मैले भन्दैछु इलोपको कुरा. लर्नेड रिसोर्स पर्सनले भन्नुभयो तपाईहरु कन्फ्युज अलिकति भएको छ. बोर्डर लाइन भनेको चाहिँ 17 वर्ष 9 महिना 17 वर्ष 11 महिना त्यस्तो केसेसहरुमा चाहिँ सुप्रिम कोर्ट त म भन्न सक्दिनँ, हाई कोर्टहरुले त्यसलाई अलिकति रिल्याक्स गरेको छ. किन भन्नुस् त, मेन प्रोभिजन, मेन इन्टेन्सन अफ द लेजिस्लेचर चाहिँ के हो, हामीले अर्काको इच्छा विरुद्ध नाबालिगा नानीहरुलाई त्यस्तो काण्ड गरेपछि यसलाई चाहिँ पठाउनु पर्छ जेल भन्ने हो नि त. के हुन्छ भने पक्सो एक्टमा यहाँ सुन्नुस् है, प्र्याक्टिकल कुरा गर्दैछु. रेजिस्ट्रेसन भएको दिनदेखि भिक्टिम बदनाम भयो, केटा बदनाम भयो, केटाको घर बदनाम भयो, केटीको घर बदनाम भयो. एउटा मेरो केसमा त भिक्टिमै मरे, केटा पनि बिल्ली बात, गाउँमा पनि इन्भिटेसन छैन. काइन्डली सी द रिपरकसन अफ द्याट पर्टिकुलर एक्ट व्हेन यु आर मेकिङ इन्भेस्टिगेसन. मैले जस्टिस दिँदैछु कि खतम बनाउँदैछु गाउँै. बोर्डर लाइनमा चाहिँ तपाईको बोर्डर लाइन केस 12-13 कुरै आउँदैन, 8-9 त त्यसमा त नो कन्सेन्ट हो. तर त्यहाँ गएर चाहिँ तपाईले भराई मैले उसले भनिदिएन भने मेरो केस प्रुफ हुन्छ कि हुँदैन तपाई स्योर हुनुपर्छ. कोर्टले त जहिले पनि सेक्सन 39 र 30 हेर्नुस् न, आउने बित्तिकै योले गरेकै हो भनेर प्रिजम्पसन गरिहाल्छ. अनि गरेको होइन भनेर चाहिँ बर्डन केस जसरी प्रुफ गर्छन् त्यति सारा डरलाग्दो प्रुफ गर्नुपर्छ उनीहरूले. अचम्मको केस छ यो चाहिँ. अनि यहाँ के छ भन्देखिलाई चाहिँ सेक्सन 39 र 30 हेर्नुस्, 29 र 30 हेर्नुस्. सेक्सन 114 अफ इन्डियन एभिडेन्स जस्तो होइन, तिमीले गरेको यो कोर्टले प्रिज्युम त्यही गरिहाल्छ. पक्का गरेको तिमी. र मैले गरेको छुइनँ हो, म भगवान पनि होइन, छाती खोलेर कसरी देखाउनु, गरेको छुइनँ भन्दाखेरि चाहिँ बियोन्ड रिजनेबल डाउट एक्युज हेज टु प्रुभ. त्यस्तो डरलाग्दो कानुन हो यो चाहिँ, पठाइदिइहाल्छ जेल। त्यस कारणले गर्दाखेरि जेल पनि कहाँ 1-2 महिना हो त, बोर्डर लाइनमा मात्रै तपाईँले अलिकति यसलाई हेरविचार गर्नुहोस्। जहाँ चाहिँ भिक्टिम छ, माइनर छ, आँखा चिम गरेर प्रोभाइडेड बर्थ सर्टिफिकेट हेज टु बी प्रुफ एज पर दि प्रोभिजन अफ इन्डियन एभिडेन्स एक्ट। के छ, बर्थ सर्टिफिकेट ल्याउँछ, कन्टेन्ट्स अफ द प्रुफ गर्छ, तर ट्रुथ अफ कन्टेन्ट्स अफ डकुमेन्ट्स प्रुफ गर्दैन। फेरि ट्रुथ अफ कन्टेन्ट्स अफ डकुमेन्ट भनेको के हो? कन्टेन्ट्स अफ डकुमेन्ट भनेको चाहिँ यो यति वर्ष भएछ यो नानी हो यहाँ हस्पिटलमा जन्मिन्छ, त्यो चाहिँ कन्टेन्ट्स अफ प्रुफ। ट्रुथ अफ कन्टेन्ट्स अफ डकुमेन्ट्स भनेको चाहिँ को थियो अथर, व्यक्तिगत नलेज भएको मान्छे को थियो, त्यो चाहिँ प्रड्युसै गर्दैन आयोले। हो यहाँ चाहिँ मार खान्छ भन्छ, ए कोर्टले छोड्थ्यो या दुःख गरेको, कसरी चाहिँ कन्भिक्सन एक्युटल भयो भन्छ, त्यही भन्छ। कुदेर जान्छ प्रोसिक्युसनको सर्टिफिकेट कपी लिएर हेड क्वार्टरमा पठाउनुको लागि, छिट्टो गर लो। किन भन्नुहोस् त, इन्डियन एभिडेन्स एक्ट 1872 चाहिँ अहिले भारत स्वतन्त्र भएर कति साल भयो? आइपिसीले यो चेन्ज गर्नु अलिकति पनि हिम्मत पनि गरेको छैन। त्यस्तो बनाएको थियो ब्रिटिसहरूले कानुन, ब्यारिस्टर पढ्ने मान्छेले बनाएको थियो उहाँ फरेन कन्ट्रीमा, युके र आइरिसमा। चलाएको छैन, 1872मा बनाएको कानुन चलाएको छैन। अनि त्यो 165 जति सेक्सन छ त्यो पढ्दैन। 67 उरु पढ्नुहोस् न, सेक्सन 67। अब यो उहाँले भन्दैछ मोबाइलमा क्याप्चर गर्यो, मोबाइल पनि प्रड्युस गर्यो, 165 पनि कन्फ्युज टोटली। When you are producing primary evidence, certificate is not necessary. When you are transforming, you transfer that video to another equipment, electronic equipment, then you have to submit 65B. Primary evidence हुँदाखेरि चाहिँदैन 65B. Secondary evidence section 65 हेर्नुहोस्, 63 हेर्नुहोस्, त्यति बेला मात्रै सेक्सन 65B को सर्टिफिकेट चाहिन्छ। तर ओरिजिनलै लिएपछि के को चाहिँदैन। हो यहाँ कन्फ्युजन छ यो अफ द केसको। फेरि त्यस कारणले गर्दा इन्डियन एभिडेन्स पढ्नुहोस्, यसलाई 1000 ताल पढ्नुहोस्, प्रत्येक वर्डलाई केलाएर हेर्नुहोस्, कहीँ पनि तपाईँको केस फेल हुँदैन, कहीँ पनि हुँदैन। तर हामी सिआरपिसी, आइपिसी र पक्सो एक्ट पनि फाइल गर्थ्यो, भित्र गुदी चाहिँ छैन, टिक्दैन, कहाँबाट टिक्छ? त्यस्तो छ। बोर्डर लाइनमा मात्रै तपाईँहरू कन्फ्युजन अलिकति, तर माइनर बिलो द एज अफ 18 छ भनेदेखिलाई चाहिँ कुरा आएन। त्यहाँबाट खुस्किएर गयो भने मैले भने क्रिमिनल एमेन्डमेन्ट एक्ट 2013 संसदले बनाएको छ, राम्रो चार्जसिट फाइल गरेछ भनेदेखिलाई चाहिँ आइपिसीबाट उम्किँदैन। त्यति छ।
बिलो 10 इयर्स छ, त्यो फिजिकली थाहा भइहाल्छ कि यो चाहिँ क्लिन डिलिङ दिँदै होला। त्यस्तोमा सपोज बर्थ सर्टिफिकेट राम्रोसँग प्रुभ गर्न सक्दैन।
यस्तो लाइक आई सेड नो, आजकल त धेरै सजिलो छ नि, पहिला पो साह्रो थियो होइन। आजकल चाहिँ एभ्री प्रेग्नेन्सी एनीवेयर इन इन्डिया इज मोनिटर्ड। अब झन् सिक्किममा हो भने वी आर अ स्मलर स्टेट कि मोनिटरिङ इज मच बेटर देन अदर स्टेट्स। आशा वर्कर या गाउँको हेल्थ वर्करलाई त उसलाई याद हुन्छ यो कुन सालमा जन्मेको या यसको आमा कहाँको हो, कहिले प्रेग्नेन्ट भएको होइन। देयर विल बी सम मेडिकल रेकर्ड अबाउट द मदर्स प्रेग्नेन्सी अर द बर्थ। अब बर्थ सर्टिफिकेट छैन अरे, हेल्थमा त उसको रेकर्ड हुनैपर्छ। बिकज इभन इफ इट इज नट एन इन्स्टिट्युसनल बर्थ, माने घरमा जन्मेको नानी हो भए पनि द स्टेट विल हेभ अ रेकर्ड अफ द चाइल्ड्स बर्थ। अब तर इट इज इम्पोसिबल द्याट यु विल नट गेट एजुकेसनल के भन्छ प्रुफ अफ डेट अफ अ बर्थ, बिकज राइट टु एजुकेसनले गरेर अलमोस्ट एभ्री चाइल्ड इज एडमिटेड इन स्कुल। अब ड्रप आउट गऱ्यो भए पनि एट सम पोइन्ट दे वेन्ट टु स्कुल, सो यु विल फाइन्ड सम रेकर्ड। अब यसो सट्टै यसो इन्भेस्टिगेसन गर्दा यो स्कुल गएको छैन, ए ला ओके यु अज्युम ला अब स्कुल सर्टिफिकेट छैन। बट इफ यु इन्क्वायर प्रपरली एट सम स्टेज स्कुल गएको हुनुपर्ने हो। लो स्कुल गएन अरे, कहाँ जन्मियो, लाइक आई सेड देयर विल बी सम हेल्थ रेकर्ड। पहिला हुन्थेन, बट नाउ इज इट्स म्यान्डेटरी। त्यो CMO will get into problem if he does not have every birth or death recorded in that CMO's district. And अर्को कुरा सरले अहिले भन्नुभयो नि सेक्सन 2930 जस्तो NDPS एक्टमा पनि छ। You have such a weapon in your hands, it has a reverse burden. IPC को केस के हुन्छ, अरू एक्ट्स को केस के हुन्छ? You have to prove beyond reasonable doubt. Burden is on the prosecution. भारत prosecution लाई छ नि कि हालनाले यो अपराध गरेकै हो भनेर. But in the case of POCSO and NDPS, burden is ulta. That is why we see reverse burden. Accused has to prove that he did not have that intention. Accused has to prove that he was mentally not sound. He has to prove that he is innocent. Now, but our doctrine is what? Law case. Innocent until proven guilty. Here it is reversed. We presume, court has to presume he is guilty until he proves he is innocent. That is the reverse burden in POCSO. Even in NDPS form, this is the
को अहिले चाहिँ 15 दिनभित्रमा रेजिस्ट्रेसन गर्नुपर्छ बदको होइन, तर अब यो कतिवटा अज्ञानता कारणले गर्दाखेरि दे विल रेजिस्टर आफ्टर 1 year 2 year and you'll produce that document before the court along with charge sheet. The problem here, this legal implication is, if the guardian is registering date of birth of the minor child after 1 year, kindly go through the provision of registration of Births and Death Act 1969 something. After 1 year report गर्दैछ, they have to follow certain procedure. पञ्चायतको recommendation लिएर सट्टै गर्नु हुँदैन. My request, if I say the relevant provision you will not read, you go through the registration of Births and Deaths Act. Maybe I think exactly I am not able to recall 1969. त्यहाँ चाहिँ 1 वर्ष पछाडि चाहिँ बर्थ सर्टिफिकेट बनाउँदैछ नाबालिका नानीको या ठुलै क्लास 8-9 भने चाहिँ सर्टेन प्रोसिजर हेज टु बी कम्प्लाइड. इफ नट कम्प्लाइड, प्रोड्युस डकुमेन्ट बर्थ सर्टिफिकेट कोर्ट विल नट एडमिट बिकज द्याट इज अ भायोलेसन अफ म्यान्डेटरी स्ट्याच्युटरी प्रोभिजन अफ द ल. त्यहाँ पनि तपाईँ कन्फ्युज हुन्छ, अरे कोर्टले त सबै छ, यो कोर्टले मानेको छ नि के हो. यु गो थ्रु द जजमेन्ट अफ द कोर्ट. गार्जियन हेज टु फलो रेजिस्ट्रेसन. अब बर्थ सर्टिफिकेट चाहिँ जन्मिन्छ एक्टको आधारमा होइन, त्यो एक्टकै प्रोभिजन भायोलेसन गरेर पाइरहेको छ, निकालिरहेको छ कागज. त्यो एक्टमै तपाईँले कसरी हुन्छ? तपाईँ समुद्रमा पनि बस्ने, गोहीसँग पनि शत्रु गर्ने हुन्छ? त्यस्तो हुँदैन नि, मिलेर बस्नु पर्यो. इफ यु वान्ट टु रिलाइ बर्थ एन्ड डेथ birth certificate of the child, you have to comply, you have to see whether there is any violation of birth and death certificate Act of 1969 or not. If guardian they are registering case of birth after 1 year, they have to comply the provision. त्यहाँ provision के छ? कसले रिपोर्ट गर्ने, मेजिस्ट्रेट को पनि कसरी कन्सेन्टहरु ल्याउनु पर्छ. त्यो गरेर लिएको छ के त? लेकै छैन, कोर्टलाई भन्छ ए कोर्टले छोड्दियो नि, बर्थ सर्टिफिकेट त दुःख गरेर लेख्थ्यो, यहाँ के हो कोर्ट केस भन्छ. त्यसकारणले गर्दाखेरि even Supreme Court also cannot add even a single word in the act. We are now here in the subordinate judiciary. We have to comply the provision of the act. Our task is just to interpret the law only, not to substitute any provision. जस्तो छ त्यस्तै उसलाई उतारेर जिउँदै के हुन्छ सिनापाना गर्नु. तपाईहरुले भन्छ बर्थ सर्टिफिकेट त लिएको थियो, बर्थ सर्टिफिकेट लिएको छ, बर्थ सर्टिफिकेट बनाएको छ, 1 वर्ष अगाडि पछाडी कसरी रिलाइ गर्छ त्यो पनि तपाईहरुले हेर्नुस्. जस्ट माइ सजेसन ओन्ली तपाईहरुको नलेजको लागि.
यसमा I just want to add, सरले भन्नुभएको जस्तो 1 वर्ष register the birth, but सरले भन्नुभएको जस्तो there is a procedure to be followed. Now if they have got that birth certificate 1 year later, तपाईले त्यो birth certificate produce गर्नुभयो अरे, but if they had not followed the procedure, like उनीहरुले SDM या DM को report हुनुपर्छ, it has to be verified, panchayat verification हुनुपर्छ. If they have not completed that registration and procedure, and it has been just issued by the registrar births and deaths, it's a delayed registration 1 year baadma, but it is the parents don't have any birth certificate, so I'm issuing. Court will not accept that birth certificate. अब उनीहरुले यस्तो छ नि, आजकल the registrar births and deaths are very careful. They will ask because they know the procedure, so they will ask. But in between, nowadays everybody is careful, but there are some birth certificates which were issued delayed registration. थुप्रो जनाको छ नि, तर त्यसमा अब कति चाहिँ चिनाजाना सर भनाइदिनुस् न. यिनीहरू चिनिरहेको ल बनाइदिन्छु। अब इन गुड फेथ उसलाई थाहा छ हो नानी जन्मेको 1 year अगाडि बनाउनु भयो, तर प्रोसिजर इज नट फलोड, पर्पस इज डिफिटेड, वी आर लाइक सर सेज बाउन्ड बाई द ल, वी क्यानट एड, वी क्यानट युज अ पर्सनल नलेज, वी क्यानट डु थिङ्स इन गुड फेथ, we have to follow the provision, we have to follow the law, so we cannot accept it as reliable evidence.
एज एन आयो चाहिँ हामीले यसमा सपोज यस्तो खालको केसेस हाइपोथेटिकल एउटा केस आयो भने यसमा चाहिँ हामीले के गर्नुपर्छ एज एन आयो? रेजिस्ट्रारको एक्स्ट्रा रेक्विजिसन मागेर हामीले उसलाई त्यो पनि प्रोभाइड गर्नु हुनुपर्छ जो चाहिँ रिक्वायर्ड वेदर यो लिगली बनाएको छ कि छैन भनेर।
यी म्याडम जति पनि डकुमेन्ट्सहरू हामीले सब्मिट गरेको हुन्छ जो पनि एप्लिकेन्ट हुन्छ या त त्यो टिमको गार्जियन हुन्छ त्यो डकुमेन्ट्स हामीले सिज गर्छौँ।
डकुमेन्ट्स भने
जुन चाहिँ अघि
डिलेड रेजिस्ट्रेसन त्यो चाहिँ यु क्यान इन्भेस्टिगेसन गर्दाखेरि तपाईँहरूले के गर्नु सक्नुहुन्छ भने गो टु द कन्सर्न कलेक्ट्रेटमा जे वेदर दे ह्याड अप्लाइड फर द के भन्छ भेरिफिकेसन रिपोर्ट के रिपोर्ट द प्रोसिजर आई थिङ्क इट्स लेस डाउन नो द्याट यु हेभ टु गेट रिपोर्ट अफ द एसडिएम रिपोर्ट अफ द पञ्चायत and see the registration officer ko त्यो files ma ke थियो त्यति बेला, and whether the IO had whether the DM had given his report based on what document. You will find the records, you can seize that, you can get certified copies of that. या registrar birth and death को त्यहाँ उनीहरूले के produce गरेको थियो, you can take certified copies of that.
अब यस्तो हुन्छ तपाईलाई थाहा भयो यो जालिम डकुमेन्ट हो भनेर हो कि हैन, त्यति बेला तपाईले रेज गर्छ यो के गर्नुपर्ने भन्ने अन्युअल एउटा तपाईको के भन्छ धर्म सङ्कटमा पर्छ हैन। त्यसैले इज आई अफ द केस नाउ which procedure you want to adopt. बर्थ सर्टिफिकेट त गयो, अब के गर्ने? देयर इज अ जेन्युन नाउ रिजन टु प्रोसिड नेक्स्ट स्टेप्स। स्कुलको पनि छैन, बर्थ सर्टिफिकेट पनि छैन, फेरि जानु पर्यो ओसिफिकेसन टेस्ट। यो डकुमेन्ट भएर फेरि ओसिफिकेसन टेस्ट भने मामुर्ख फेरि, किनभने आयोले नै विश्वास छैन ओसिफिकेसन टेस्ट भइरहेको छ भन्छ, कोर्टमा त्यही सबमिसन गर्छ हैन डिफेन्सले। आयो इज नट 100% sure, he produced on top of that he produced ossification test also. Now here you have a genuine ground to proceed with ossification test. अब तपाईले यो के भन्छ यो जालिम डकुमेन्टमा त्यो बनाउनु त फेरि अर्को के सुरु हुन्छ, फेरि जान्छ पञ्चायतहरु। त्यो त इन्टेन्सन होइन नि तपाईको त, तपाईको चाहिँ हो पक्सो केस। पक्सो केसलाई कसरी प्रुभ गर्नुपर्ने? If that part document fails, then you have to proceed ahead another steps. But having document or birth certificate and school certificate in your possession, you cannot proceed ossification test. And here now you have a genuine reason to proceed. तपाईले लडेड रिसोर्स पर्सनले भन्नुभएको तपाईले भेरिफिकेसन गर्नु पर्यो चाहिँ। Without verification you cannot jump, and you have to draw the conclusion in your charge sheet saying that after having verified so and so record, I am not satisfied, then I opted ossification test. Getting my point what I am saying? त्यस कारणले गर्दाखेरि यहाँ चाहिँ अलि अन्धा धुन्दामा रेजिस्ट्रेसन एक्ट थाहै छैन, चार्जसिट फाइल गर्थ्यो, अबर पर्यो आयो जसरी बाघ पिँजडामा पसेको जस्तो। केस प्रुफ त होइन, आफै कसरी उक्सिनु कोर्टमा त्यो पो भइरहेछ। अदरवाइज देयर विल बी स्ट्रिक्चर इन द जजमेन्ट, and there is a judgment of Hon'ble Supreme Court saying that I don't want to refer that particular judgment. What judgment of Hon'ble Supreme Court says, if there is negligence on the part of the IU and there is a ignorance on the part of the IU case while making investigation of any criminal cases. यहाँ चाहिँ तपाईको नलेज छ त आफै सेल्टरमा पसिहाल्यो नि त, तपाई सुरक्षित भयो भने पो केस ग्रुप हुन्छ त, आफै असुरक्षित भएर पसिरहेछ कोर्टमा। 100% तपाई जानुस् न एकदम पोलाइटली दिस इज द रिजन भनेर। त्यसकारणले गर्दाखेरि हामीले तपाईहरुलाई यहाँ तर्साएको होइन, सेन्सिटाइज गरेको। देयर मे बी सर्कमस्टान्सेस इन फ्युचर, यु मे कम एक्रॉस केसेस लाइक दिस, काइन्डली बी अलर्ट भनेर। अनि विल रिक्वेस्ट एभ्री अफिसर प्रेजेन्ट हियर टु काइन्डली रिड रेजिस्ट्रेसन अफ बर्थ एन्ड डेथ एक्ट के भनेको छ, त्यहाँ के भनेको रहेछ त्यसलाई जुझाएर हेर्नुहोस्, राम्रो प्रकारले बेलुका आरामले हेर्नुहोस् न, किन अतालिनु। अनि एक्सन प्लान बनाउनुहोस्। यस्तो गरे ए भिक्टिमको उयो आयो लु एक्जामिन गरियो मैले अब त्यस्तो हुँदैन नि एक्सन प्लान हो त्यस कारण यु हेभ टु केस प्रिपेयर केस डायरी त लाखालिङ्गै हुन्छ तपाईँहरूको विथ अल रेस्पेक्ट जति बेला आयो त्यति बेला एक्जामिन गरेछ यहाँ ओहो लुरै नैन सी जर्नलिस्टमा मती बनाउनुपर्छ भने एक्सन प्लान छैन मजाले एक्सन प्लान बनाउनुहोस् त्यहाँदेखि आइडेन्टिफाई गर्नुहोस् यसले मलाई धोका दिँदैन यो मान्छेले आई हेभ फार्म बिलिभ आई एम 100% स्योर दिस पर्सन विल नट मिसलिड द कोर्ट एन्ड मिसलिड मी अल्सो त्यस्तो खालको बनाउनुहोस् जस्तो सजिलो त्यस्तो प्रकारले
Which is more important? So your birth certificate and matriculation certificate. Primary.
प्राइमेरी चाहिँ बर्थ सर्टिफिकेट चाहिँ इम्पोर्टेन्ट
हाम्रोमा birth certificate छ हैन?
हजुर
It's already authenticated.
यस्तो हुन्छ यहाँ सुन्नुहोस् लमा कुन पहिले जन्मेको थियो मेट्रिकुलेसन सर्टिफिकेट जहिले पनि दिमाग छिपिएर बनाएको हुन्छ पहिले चाहिँ कुन चाहिँ हो डकुमेन्ट चाहिँ यदि बर्थ सर्टिफिकेट चाहिँ तपाईँको प्रुभ गर्नु सक्यो भने देयर इज नो क्वेसन अफ लाइङ इफ बोथ आर टेलिङ टुगेदर
No sir. I have faced a situation where COVID को टाइममा थियो सर
हजुर
schools and all like सबै क्लोज थियो
हजुर
तर birth certificate production गरेर पनि matriculation certificate चाहिँ त्यो production नगर्नेसम्म चाहिँ प्रब्लमै थियो
This is why your case हेर्नुहोस् न
This is also
Mangala Mishra.
ma'am, मेरो case.
your case no so they have said no first is birth certificate or matriculation no
But
birth
the
certificate
judge
means
itself, ma'am,
school matriculation certificate why did I say okay ICSE CBSE reports I mean reports these are the best because nobody can challenge the authenticity of these documents no so that is why it has said even in Madhya they said first say actually you give the matriculation certificate money board exam ko cha bhane board exam छैन भने then you go to the birth certificate given by your corporation or your GMC or whoever or
so
birth
first
certificate
priority is matriculation certificate.
if board exam दिएको छ भने चाहिँ हैन
तर ma'am, त्यो COVID
if the child is in class 5
COVID
then that's not a matriculation certificate
Ma'am, during that COVID situation, it was very difficult. किनभने schools were closed for like one year, 2 years. So हामीले त्यो matriculation certificate दिँदा ओर्दा चार्जसिट पनि फाइल भइसक्यो त्यसले गर्दा डिले भएर कति इन्स्टेन्सेसमा चाहिँ त्यस्तो 5-6 वटा केसेसमा त्यस्तो भयो
no then you can give your reasons why
के हुन्छ तर पनि जज वाज सो एडमेन्ट हुन्छ नि matriculation certificate नआउनेसम्म
यस्तो हुन्छ
that will depend on different presiding
Yes,
officers
No.
10 बजेदेखि गएको 4 बजेसम्म चाहिँ हेरिङमा मात्रै त्यहाँ बस्नु
सुन्नुहोस्
I face such kind of
No, सुन्नुहोस् यस्तो हुन्छ read kind 173 always keep vacuum space in your charge sheet I will file supplementary charge sheet so and so getting my point there is a provision छ CRPC मा यहाँ यस्तो हुन्छ नि कसैको व्यक्तिगत कुरा होइन कानुन चाहिँ के छ कानुन देखाऊ अघि बढाऊ क्वालिटीको रेस्पेक्ट गर्नु पर्यो if court is not accepting there is a provision in CRPC where to go if court is not accepting your charge sheet you can't be helpless because you have to prove your case there is a provision of revision there is a provision of appeal in higher court but you can't keep mom saying that डराएर यस्तो होइन तर you have to satisfy under the provision of law
certificate
see it's like this first instance class 10 pass गरेको छ भने class 10 certificate त्यो पाउन सकेन अरे कोभिड टाइम भयो you are not able to get what is the second option birth certificate no
it was already filed ma'am.
yes so that is fine so but there you have to say why you opted for the second if the child has appeared for a board exam
I have the reason also ma'am. त्यो के भन्छ COVID
Then-
you are confusing yourself your document is contradictory because you have filed birth certificate you are not 100% sure
No, it was authenticated sir. Authentication later पनि it was 100% genuine.
then why is question
के अरे matriculation certificate चाहिँ primary हो भनेर चाहिँ त्यसमा
no I'm sorry but I beg to differ in this with the concerned court because it is not that it says you bring matriculation certificate plus birth certificate plus ossification हैन if in the first instance you are unable to get this is what Mahadev says first best is your matriculation but obviously a class 2 child cannot have a matriculation certificate so if there is no matriculation certificate then school first attended by the child then if that is not there then you have your birth certificate it's an option 1 option 2 option 3
matriculation certificate चाहिँ त्यो प्रिन्सिपललाई लगेर गएर स्कुल पनि खोल्न लगाएर अन्त लिएर आएको I have
So
to-
there you have the powers of
No,
investigation.
ma'am,
no?
that is like, हुन्छ नि त रिपिटेड गएर चाहिँ एक दुई महिना त्यो खोजेर पनि अब उनीहरू छुट्टीमा कहाँ
So, like sir said, तपाईँले चार्जसिट फाइल गर्नु बेलामा त्यति बेला you leave an option for yourself कि because of COVID is this but I will undertake to file it as soon as it is possible to obtain these. I will file it.
ड्युरिङ त्यो हुन्छ मेरो ट्रायलको त्यति बेला चाहिँ भएको त्यति अगाडि केही थिएन बर्थ सर्टिफिकेट त्यो उयो ट्रायलमा हुने चाहिँ भएको त्यहाँ चाहिँ मलाई लिएर आउनु पर्यो नेक्स्ट ट्रायल
As additional. That it depends on court to court to see how you want to be convinced. No, maybe the court wanted every kind of evidence before it to because POCSO is not a simple thing. Minimum nowadays, you know, no. अब मैले सुने तपाईहरुले 20 years. अब Section 6 has been amended, so the court has to be extremely sure that if I'm going to convict, then I must make sure that I know I've determined the age properly.
इनफ्याक्ट तपाईँ त ग्रेटफुल हुनुपर्ने कोर्टले चाहिँ गिभिङ एन अपर्च्युनिटी टु
Give additional evidence.
एडिसनल एभिडेन्स त्यो हुनुको लागि मात्रै एपिलसम्म जान्छ त्यो टु गेट एन अपर्च्युनिटी टु फाइल सप्लिमेन्ट्री चार्ज सिट
No, I'm surprised that the defense did not object to
Yes.
that because they will not allow additional evidence in the middle of a trial.
यसमा चाहिँ
जजले तपाईँको जज साहब चाहिँ तपाईँको फेभरमा लागेको रहेछ यसमा
सर यसमा के हुन्छ भने युजली बर्थ सर्टिफिकेट छ भने हामी त्यसमै रिलाइ गरिहाल्छौँ त्यो रिलाइ गरेर हामीले चार्जसिट फाइल गर्दैछौँ बादमा चाहिँ अब कोर्टको अझै तपाईँले भन्नुभएको जस्तो केस राम्रो बनाउनु लागि उहाँले बिचमा भन्नुहुन्छ कि फर्स्ट एडमिसन रेजिस्टर कहाँ छ त्यति बेला खोज्छ नि
It's the only because what you have done is, courts you all have done birth certificate, birth register, school certificate, school register, authentication report. You have filed under every category. And the koi case, even ossification, which makes it appear that you're not sure of the date of birth of the child. No. If you are sure, you produce the parents first. Like I always say, parents are the best. Anish Raiko case here, no, so I'm not sure. Just look for Anish Rai. This is one of the judgments from here. It's not here. Parents are the best witnesses, and if it is supported by an authentic document. Parents produce gunos, you produce the birth certificate. Parents produce gunos, produce a matriculation certificate.
यस्तो हुन्छ जहाँ पनि तपाईँ कन्फ्युज हुनुहुन्छ नि whenever you come across any cases you have to go through the authority of Supreme Court and High Courts, own High Courts. यसमा के डिसाइड भएको छ getting my point? Then you will be 100% sure. कसले भन्दिने बिचरा आयोलाई खोजेको छ बर्थ सर्टिफिकेट कसैले हेल्प गर्दैन आयोलाई मलाई थाहा छ त्यही आफ्नो सबनेटले हेल्प गर्छ त्यो पनि तपाईँको भन्दा मिनिमम एक्सपिरियन्स र नलेज भएको हुन्छ कसले हेल्प गर्ने त्यसैले अलवेज in this regime of information technology go through the information technology take the center of information technology अथोरिटी के भनेको छ सुप्रिम कोर्टले यो विषयमा हेर्नुहोस् त्यहाँ पढ्नुहोस् अब सुप्रिम कोर्टले अब मैले सुन्दैछु यो डाइरेक्टोरेट अफ प्रोसिक्युसन हुन्छ तपाईँहरूको एउटा लिगल पर्सन पनि चुन्छ आईओलाई सपोर्ट गर्ने भने किनभने यु आर नट सपोज टु टेक द सेन्टर अफ पिपी वेल मेकिङ इन्भेस्टिगेसन द्याट इज स्पेसिफिक जजमेन्ट कसले हेल्प गर्ने त्यस कारणले गर्दाखेरि यु टेक दिस सेल्टर अफ जजमेन्ट अफ हनेबल सुप्रिम कोर्ट एन्ड हनेबल हाई कोर्ट अफ सिक्किम सबै जजमेन्ट अलरेडी दिएको छ अपलोड गरिरहेको छ वेबसाइटमा पर्दैन किन पर्दैन भन्नुहोस् त कसले भन्ने पढ्ने कुन चाहिँ जजमेन्ट कहाँ छ कसरी हेर्ने अहिले ESCR हामीले अस्ति यहाँ ट्रेनिङ गऱ्यौँ हाम्रो जुडिसियल अफिसरलाई बार मेम्बरलाई ESCR मा सबै पाउँछ केही तिर्नु पर्दैन तर के छ पर्दैन तपाईहरुको डायरी छैन तपाईको डायरी चाहिँ जति एक्सपिरियन्स हुँदैछ पीआई हुँदाखेरि चाहिँ यत्रो थाक हुनुपर्ने कति केस गर्यो भन्दाखेरि तलको युपीको आयोले के भन्छ मैले 15,000 केस गरे 27,000 केस गरे यो साइटेसन छ भन्छ अनि के हुन्छ त्यहाँदेखि तपाईको सुप्रियर अफिसर पनि तपाईलाई रेस्पेक्ट गर्छ किनभने हि हेज अ क्वालिटी कन्फ्युज छ जहाँ कन्फ्युज छ अथोरिटी हेर्नुस् जहाँ कन्फ्युज छ लाइन बाइ लाइन हेर्नुस् प्रोभिजन अफ द ल 10 टाइम्स 13 टाइम्स पढ्नुस् के भनेको छ यु आर नट 100% स्योर एन्ड अन द डाइरेक्सन अफ concerned Honorable Court, you are procuring the document. You have a right to 173 मा तपाईं पाउँछ document submit गर्नु. तर if you are 100%
I
sure,
was 100% sure.
then
Like, no, मेरो तर्फबाट I was damn 100% sure कि birth certificate सबै छ, त्यसको authentication पनि registerदेखि लिएर सबै छ. तर कोर्टबाट चाहिँ मलाई उयो गरेको छ.
त्यसकारण there was a communication gap between PP and I of the case.
हैन यो चाहिँ सर यो
What was the expression of the court to the PP was not disclosed by PP to I of the case.
So मेरो चाहिँ यो भनेको छ अब if the birth certificate is already there, it's already authenticated, it's all 100% genuine. त्यसमा चाहिँ अब जुन चाहिँ त्यो टाइममा पनि अब
Like तपाईले भन्नु हुँदैछ नि, is 100% authenticated, you're saying, no? It's 100% genuine. Okay, no doubt about its veracity. It's got the seal of the registrar birth. That's
it was not even borderline case ma.
Minor, but maybe you did not list the person who wrote the contents of the birth certificate. Dealing assistant here.
यस्तो हुन्छ
What then?
यस्तो हुन्छ हेर्नुस् केस भनेको यस्तो कुरा हुन्छ के अचम्म केस हुन्छ भने नि तपाईको छेउमा पक्का हो भन्छ भन्दैन कोर्टमा म त के भन्नु पुलिसले यसो गर्दैछ म त गएको थिएँ नि त्यहाँ मलाई के थाहा उसको नानी कति बेला जन्मियो मलाई त यहाँ जानु भने सिग्नेचर गर्यो कोर्टलाई भन्दिदैन तपाईको जुन चाहिँ मान्छेले चाहिँ सिग्नेचर प्रुफ गर्नुपर्छ नि तपाई 100% स्योर नहोस् उसले भन्दैन कोर्टमा त्यसै कारण सुप्रिम कोर्टको जजमेन्ट छ आईओ हैज टु बी देयर इन द प्रोसिडिङ भन्यो इम्पोर्टेन्ट विटनेसमा आईओ क्यान कम एन्ड सिट इन द कोर्ट उसले भन्दैन म आँगनबाडी वर्कर मैले हस्पिटलमा देखेर उहाँ रेजिस्टरले भनेको भन्दैन कोर्टमा त्यसै कारणले गर्दाखेरि कोर्टले इन्सिस्ट गरेको तपाईको मेहनत
देखेर it's a good thing that court asked for additional evidence because that's a good sign. Let me give you a tip from that. It's a good sign if court is saying like give me more evidence.
Yes.
Because court is finding maybe the evidence is lacking somewhere. Court wants to be convinced so that if you're working towards determining the age, no? Court wants to make the child a minor. You want more evidence to be sure.
Court has reached 50-50.
Borderline is asking for the future, like even we.
No. Therefore, I am suggesting you don't make sure that witness will say same thing. Recorded in your 161 statement.
So now what I'm asking you to.
No. You go with the what is the law laid down. Don't go by other things. Go by what is the law laid down.
Primary documents like matriculation or birth certificate. What do we collect?
If you have both, file both. Look. Best. If you want to file, because you're not in the habit, no, you feel that my birth certificate, matriculation, now there's a possibility I've done incomplete. If you're convinced that you feel confident with both, file both. Not necessary, but you can file both.
यसमा चाहिँ के हुन्छ म्याम हामीले एउटा हालेको छ भने लाइकवाइज अब यहाँ त म्याम प्रायः जस्तो इन्भेस्टिगेटिङ अफिसर मात्रै छ हाम्रो सुपिरियर रुम हुनुहुन्छ नि
उहाँले इन्सिस्ट गर्नुहुन्छ ठिकै छ ल ओके टु बी अन द सेफ साइड भने बट द लॉ डज नॉट रिक्वायर लेट मी टेल यू लॉ डज नॉट रिक्वायर 2 3 लॉ रिक्वायर्स 1 फर्स्ट ऑप्शन
One section 134 of Indian evidence says court requires quality not quantity. बुझ्नु भएन but only where I request you to apply your mind is while keeping both documents in juxtaposition, telling each other or not, that is relevant. And who is going to prove what?
And
context?
if they contradict, you've had it. If
Yes,
you file both, make sure that तपाईको witnessले पनि corroborate गर्छ एउटा अर्कोलाई. Because यस्तो छ नि तपाईको your PP will have to, it is now तपाईले जे गर्नु थियो तपाईले गर्नुभयो हैन. Now it is the PP's job. Now PP has to convince the court, look, our documents are in place. I don't even need the second birth certificate, but here, investigating officer यति दुःख गरेको छ, लु यो पनि फाइल गरेको छ. But in my case, just the parents को is enough, or just this के भन्छ matriculation is enough. But on top of that, we are filing this also. It depends on the PP's presentation, and then you go supported with Mahadev, with Mangal Mishra, with Anish Rai. Viratmal.
Same thing, मेरो मसँग पनि भएको थिएन, लाइक के भन्नुहोस् मेरो केसमा पनि लाइक यु सेड earlier, victim was 8-year-old kid, 8 वर्षको मात्रै थियो, and it was quite evident देख्दाखेरि पनि माइनरै हो. And I submitted the original birth certificate along with the first school admission register. त्यतिखेर चाहिँ लाइक मैले अघि पनि भने म्याम I was asked to produce the ICDS को ICDS को register को extract submit गर्नु भनेर.
So you have given the reason, there was no record भनेर हैन. So that is when you cannot produce documents, you cannot manufacture documents, na. So you give the honest answer. I don't have it. Thena. But here now, what all your hard work say, it is now up to the PP and your witnesses. Now, तपाईले कस्तो witness list गर्नु भएको छ? You may have listed 5, like I said, no, but you must have relevant witnesses. Like he said, quality over quantity. For us, it does not matter. We are not going to look at the charges and say like, mom, 34 witnesses, must be very good investigation. No. Very often, more often than not, I will tell you this much, cases with the least number of witnesses are the cases which are proved. Jati witness beshi, the chances of not corroborating each other, more danger. They will contradict each other. So if you find that a witness is not useless, you are not relevant, don't list him. Kosto witness also koi ke bela? Witness number 25, okay, bola. What do you have to say? म त यस्तो डरमा यस्तो पुलिस आएको हेरिरहेको थियो अन्त यसो आउनु भन्यो डेड बडी बोक्नु भन्यो म त सकाए. What is his contribution to the case for proving your case? तल बाटोसम्म बोक्नु सकाइदियो, सरले साथी गर्नु भन्यो, मैले खुट्टा समातिदियो. Nothing, not relevant. Oh, I heard, मैले त त्यहाँ यसो त्यहाँ मर्डर भयो भनेर सुन्यो. This is just the other day. म पनि गएको थियो गाउँमा, त्यो आँगनमा मैले यसो हेऱ्यो, पुलिसहरू आउनुभयो. त्यहाँ पछि मैले सुन्दाखेरि हाल्नाले पो यस्तो बन्चरोले हिर्काएर मारेको रहेछ. Can't even rely on that evidence because it's hearsay. No point listing him. You know that. So don't, when you are investigating, you will meet so many witnesses, but तपाईले चाल्नु पर्यो. You don't need everybody that you examine. You will have more danger of them creating problem in your case.
More witnesses, they will contradict your case. यसले भन्छ फल्नाले मैले देखेको थिएँ, अर्को विटनेस आउँछ देखिन. डिफेन्सले भन्छ हेर्नुहोस् त, आयोले दुईटा विटनेस बनाएको छ, यो दुईजनाले देखिन भन्छ, कसलाई विश्वास गर्ने हजुर तपाईँ?
सो त्यो चाहिँ डिफेन्सले मेनली हाम्रो उयसमा चाहिँ कतिवटा सादा केसेसमा भन्नुहुन्छ. सादा केसेसमा चाहिँ विटनेस अगाडि नै डिफेन्ससँग भेटेकै हुन्छ. अब हामीले विटनेसलाई
So therefore, just I remind you, there is now witness protection scheme. बुझ्नुभयो? Goals जानुहोस्, there is a witness protection scheme. That I think bill has, I am not able to update myself. Already आइसकेको छ. Already आइसकेको छ. त्यो पढ्नुहोस् तपाईले. You can take shelter in that particular circumstances. किनभने आयोले गएर त्यसलाई पिट्नु त सक्दैन. तपाईले खाली कानुन देखाउने हो, कानुनको भित्र काम गर्ने हो.
If we find a connection between the defense and the witness, like over the phone or anything, we can frame हामीले त्यो डिफेन्सको अगेन्स्ट के गर्न सक्छ?
त्यो चाहिँ यस्तो हुन्छ तपाईको. तपाईको यस्तो यो चाहिँ के हुन्छ भन्नेलाई चाहिँ if any evidence given before the court in any case त्यो त पर्जरी भयो. त्यसमा तपाईको फेरि लन्ठा छ, बहुत लन्ठा छ.
लन्ठै होस् कति हो कस्तो
हैन, यहाँ सुन्नुस्. लन्ठा के छ भन्नुस् त?
That's a very good attitude. छोड्दिउ भने चाहिँ is not a good attitude.
लन्ठा के छ भने प्रिसाइडिङ अफिसरले कम्प्लेन गर्नु पर्यो. 195 section 1, kindly I request you everybody, every officer, kindly note down section 195. बुझ्नु भएन? प्रिसाइडिङ अफिसर गएर कम्प्लेन गर्नु पर्यो सिजिएम कोमा. ऊ कम्प्लेन हुनु पर्यो. बुझ्नु भएन? कोर्टमा चाहिँ झुठो फाइन दिएको हो. कसले गर्छ भन्नुस् त लु? किन टको दुखाउँ? एउटा केस डिस्पोज गर्नु छैन, हाई कोर्टबाट आएको छ इन्भिटेसन. फेरि अर्को केस आफै उठेर जानु, अर्को हडल छ. त्यसकारणले गर्दाखेरि त विटनेस प्रोटेक्सन स्किम हेर्नुहोस् तपाईले, राम्रो पढ्नुहोस्. त्यसमा के गर्नुपर्छ? किनभने आयोग केसको चाहिँ कुनै पनि एउटा सोसाइटीमा प्रब्लम भएछ, हादसा भएछ, त्यसलाई लिएर रिजल्भ गर्नु, यस्तो इन्स्टेन्सेस दिनुस्, नगर्नु है, अस्ति पुलिसले आएर पक्रेर जेल पठाएको छ, नगर्नु त्यस्तो भन्ने हो नि त। न कि त्यसलाई अर्को केस जन्मायो, फेरि अर्को जन्मायो, त्यो काम त होइन। त्यस कारणले गर्दाखेरि तपाईँले त्यो दिमागमा राखेर काम गरेको तपाईँले एकदमै राम्रो। र मेरो रिक्वेस्ट छ अरू अफिसरहरूलाई पनि, तपाईँहरूको किनभने भिडियो रेकर्डिङ हुँदैछ, हामी तपाईँको अफिसरहरूलाई पठाउँछौँ कोले कस्तो इन्ट्रेक्सन गर्यो, बसिरह्यो कि होइन, त्यसमा तपाईँहरूले पनि क्वेसन सोध्नुहोस्। जान्नै पर्छ भन्ने छैन नि त हो, एउटा उत्सुकता हुन्छ नि, यो चाहिँ मैले सोधिराख्नु के हुन्छ होइन। जस्तै एफआइआर गरेर आयो, मर्डर गऱ्यो, ऊ आफै आएर एफआइआर गरे हो किन, भन्छ डिफेन्सले हिट बाई 162। यस्तो सर्कमस्टान्सेसमा के हुन्छ, फेरि एफआइआर गऱ्यो 161 दियो, मऱ्यो मान्छे, मऱ्यो होइन, मऱ्यो, के हुन्छ त्यसको आइडेन्टिटी, त्यो डकुमेन्टहरूको। यो पार्टिकुलर प्लेसमा चाहिँ तपाईँले त्यो क्लियरिफाई गर्नुहोस्, सोध्नुहोस् भन्ने नि हो किन। तपाईँहरू अन्योलमा हुनुहुन्छ भनेपछि कहाँ सोध्ने, कहाँ जाने। अरू स्टेटमा चाहिँ डाइरेक्टोरेट प्रोसिक्युसन छ, त्यहाँ चाहिँ एउटा थुप्रै लयरहरू एपोइन्ट गरेको हुँदछ, तपाईँहरू कन्फ्युज भयो भने चाहिँ उहाँ सोध्दो रहेछ। तर तपाईँका पिपीले सोध्नु सक्दैन तपाईँले। फेरि हाम्रो त्यो के हुन्छ, इन्फेरियर सुपिरियर कम्प्लेक्स हुन्छ, अरूले सोध्यो भने ए जान्दैन यो मान्छेले, ए फोन गरिरहन्छ, सोधै गर्छ, कतिवटा केसमा सोध्नु। त्यस कारणले गर्दाखेरि इन अर्डर टु क्लियरिफाई अल दोज complex, intricate issues, here is the Sikkim Judicial Academy. We are providing platform to all officers, exchange your views, be comfortable. Court ma तपाईले सोध्न सक्नुहुन्न, हाम्रो सिनियर मोस्ट जुडिसियरीमा अब प्रिन्सिपल डिस्ट्रिक्ट हाई कोर्ट चलाएको उहाँ, त्यस्तो एक्सपिरियन्स रिसोर्स पर्सन तपाईँको अगाडि मैले राखिदिएको छु, सोध्नुहोस् अझै पनि।
सर तपाईँले भन्नुभएको सेकेन्ड सिनारियो भन्नुहुन्छ सर, त्यसमा त्यो सपोज मऱ्यो भने त्यो अटोमेटिकली सर त्यो डाइङ डिक्लेरेसन काउन्ट हुन्छ कि सर, त्यो सेक्सन 25 हिट गर्छ।
मैले भनेको डाइङ डिक्लेरेसन हुन्छ भनेर
सर, बट एनिथिङ गिभन इन फ्रन्ट अफ पुलिस अर नट एडमिसेबल हैन सर।
मलाई चाहिँ भन्नुभएको सुप्रिम कोर्टले, म जान्दिनँ अरू
सर, जस्ट क्वेरी मात्रै नि सर।
सुप्रिम कोर्टले भन्नुभएको त्यो भयो भने म जजमेन्ट तपाईँलाई दिन्छु, त्यसमा पढेर हेर्नुहोस्, किनभने मैले भनेको ल हुँदैन। सुप्रिम कोर्टले भनेको कुन आधारमा ल हुन्छ भन्नुहोस् त तपाईँहरूले, कुन प्रोभिजन अफ द ल, सुप्रिम कोर्ट ल, सुप्रिम कोर्ट जजमेन्ट इज अ ल बाइन्डिङ एक्रस द कन्ट्री टु अल कोर्ट्स। तपाईँले जानेको छैन, म भन्दिनँ कसैलाई, मलाई चाहिँ भन्नुहोस् तर खुसुकै। आर्टिकल 1 India 1950 says the judgment declared by Supreme Court is a law applicable all courts across the country. अनि त्यो सुप्रिम कोर्टको जजमेन्ट तपाईँलाई दिन्छु म खुसुकै, त्यहाँ पढ्नुहोस् के भनेको रहेछ होइन। अब मर्डर गरे, आफै आयो थानामा, मार्दै आँखा लगाए, बाउजीसँग दिए नि डङ्गाइ दिएका पुड्लुका मरे सर, म त मारे मान्छे मारेर आएको, मलाई थुन्नुहोस् भन्छ। यो हतालिरहेको छ, कसरी के हो, के भन्छ यो पग्ला हो, के हो बौला त होइन कि। अब what is the value of that particular FIR given by the accused himself? बुझ्नुभयो? तपाईँले चाहिँ कान फुक्नु पर्यो पिपीलाई, यो चाहिँ सेक्सन 8 अफ इन्डियन इभिडेन्स एक्ट 1872 मा पर्दो रहेछ है भनेर, सेक्सन 8। अब त्यो कसले भनेको, मैले भनेको होइन है, त्यो सुप्रिम कोर्टले भन्नुभएको, महागुरु उहाँ बस्नु भएको छ, बुझ्नु भएन, संविधानले पावर दिएर त्यो चाहिँ मान्नु पर्यो। अब यसमा तपाईँको निसङ्कोच हुनुहोस् न, यस्तो खालको अथोरिटी बटालेर डायरीमा लेख्नुहोस्, जति डायरीमा लेख्यो, जति क्वालिटी छ, रेस्पेक्ट हुँदै जान्छ, म्याच्योर हुँदै जान्छ, अनि तपाईँको सजिलो हुँदै जान्छ सबै कुराहरू। जहाँ त कन्फ्युज हुन्छ एकदम साह्रो हुन्छ, किनभने अध्ययनै गरेको छैन। फेरि मैले रिक्वेस्ट गर्छु म सबै अफिसरहरूलाई, घरमा तपाईँको 10 मिनट जस्तो पढ्नुहोस् तपाईँहरू, यही पढ्नुपर्छ भन्ने छैन कानुनको, अनगिनत किताबहरू छ जहाँ चाहिँ टिभी मोबाइलभन्दा डरलाग्दो तपाईँहरू एडिक्ट हुन्छ किताबहरू, तर कसैले किताब दिइराखेको छैन तपाईँहरूलाई पढोस् भनेर। आज यो जुडिसियल अफिसर अस्ति आयो, रिक्वेस्ट गर्नुभयो, सर हामी त रिटायर भएर जान्छ, तपाईँ त खालि आइपिसी सिआरपिसी मनी लन्ड्रिङ मात्रै पढाउँछ, हामी चाहिँ पैसा कसरी कमाउनु, क्लास लिनुहोस् भन्दा चाहिँ ठिकै कुरा। हाउ टु अर्न मनी, एभ्रिबडी इज इन्ट्रेस्टेड एन्ड एक्साइटेड अल्सो, राम्रो पनि हुन्छ प्रोग्राम, त्यस्तो चिजहरू पढ्नु। पढ्दै पढ्दैन त बाबा, कोही पढ्दैन। घरमा चाहिँ के छ भने अहिले के हुन्छ, शिक्षित व्यक्तिको घरमा के भन्छ थाहा छ? म गएँ भने तपाईँको लाइब्रेरी कहाँ छ भन्छु म, तपाईँको सोफा यस्तो म सोध्दिनँ, म लाइब्रेरी कहाँ छ तपाईँको? आज इन्फर्मेसन टेक्नोलोजीमा तपाईँको लाइब्रेरी र डेस्कटप ल्यापटप हुनु पऱ्यो नि, होइन? किनभनेदेखि तपाईँको नानीहरू सबै इङ्ग्लिस स्कुल पढेको होला, भोलिको दिन नानी स्कुल इङ्ग्लिस स्कुलमा आएर भन्छ, रिक्वेस्ट गर्छ, he or she will request you to prepare homework। तपाईँको होमवर्क चाहिँ कुनै सबै फेल हुन्छ, गुरुआमाले डल्लो बनाइदिन्छ। अनि तपाईँले नानीले त्यो होमवर्क हेरेर तपाईँलाई हेर्छ, see the quality of my parents, next time I make sure I will not show this homework to him, he has no quality। थर्ड टाइममा भन्छ त पापा प्लिज डोन्ट गो टु माई स्कुल, you have no fluency about language also, you don't know how to prepare also, don't go। And there will be communication gap with your kids and you। So enhance the quality for the sake of growing your children। जमाना यस्तो आएको छ है आज। र माई रिक्वेस्ट, पर्सनल रिक्वेस्ट इज काइन्डली रिड। 5 मिनट मात्रै पेपरै मात्रै पढ्नुहोस् न, लु प्रजाशक्ति मात्रै पढ्नुहोस्, तपाईँ यति ज्ञानी हुन्छ, यु क्यानट इमेजिन योरसेल्फ। अनि क्वालिटीको जमाना छ अहिले। मेरो फुटानी के हो, सिक्किम जुडिसियल एकाडेमी भएर 4वटा कम्पनी आयो, एमजी पार्कमा ठिङ्गै उभियो, मेरो दाम कति लाग्छ त्यो मेरो फुटानी। कम्पनीले मेरो दाम क्वालिटीमा कति लाउँछ त्यो चाहिँ मेरो फुटानी। पोस्ट डजन्ट मेक एनी डिफरेन्स, पोस्ट doesn't at all make any difference। The difference is your quality। I'll respect to the quality and seniority, because in age, in service, कसले जित्छ, कसले जित्नु सक्दैन। अर्को जुनीमा आयो भने मात्रै कता भयो डिम्बुचे भएर नसक्दैन। त्यस कारणले गर्दा माई रिक्वेस्ट इज काइन्डली रिड एटलिस्ट 5 minutes एट होम एन्ड रिड डिफ्रेन्ट बुक्स। अनगिनत किताबहरू छ। हेर्नुहोस् न, सिक्किम चाहिँ एउटा सानो स्टेट हो, 193 कन्ट्रीको एउटा देशको पनि 22औं राज्य हो। त्यहाँ बसेर हामी फुटानी गरिरहेको छ। वर्ल्डमा के हुँदैछ कसैलाई थाहा छैन। 193, म त 5वटा देशमा पनि गएको छु, बुझ्नु भएन। अनि सुप्रिम कोर्टको जजमेन्ट लेख्दैछ, जजेसहरूले के पढेर लेख्दैछ त्यो तपाईँहरूको चिन्तन हुनु पर्यो। के पढेर लेख्दैछ उनीहरूले? हाउ यू क्यान से दिस सुप्रिम कोर्ट जजमेन्ट इज 100% करेक्ट? Which judgment they are being referred? Why not you can't refer those books, those materials which the judges of whatever judges of high courts are referring? त्यो चिन्ता हुनु पर्यो नि। सोसाइटीलाई कति दिने, के दिने आफ्टर 10 years 20 years? So for example, there is a crisis of water in Gangtok, population double after 6 years। के हुन्छ यहाँ? हङ्गामा हुन्छ। Who is thinking that problem? अब सबै के भन्छ, हामीले खाली आइपिसी र इन्डियन एभिडेन्स हेर्दैछ, इन्फर्मेसन टेक्नोलोजीको इन्भेस्टिगेसन गर्नुपर्छ तपाईँहरूले। अहिले पनि यहाँ हेर्दै यहाँ साइबर क्राइम भइरहेछ, कसैलाई थाहा छैन, ट्रेनिङै दिएको छैन, पढेकै छैन, कसरी इन्भेस्टिगेसन गर्छ? साइबर क्राइम्सको तपाईँको इन्भेस्टिगेसन गर्ने जमाना आयो तपाईँहरूले चाहिँ। त्यस कारणले गर्दाखेरि पुरानै किताबमा संशोधन गर्दैछ। त्यसको लागि तपाईँ एबल हुनुहुन्छ त? एकात क्रिप्टो करेन्सीको म स्यालुट गर्छु उहाँ आयोलाई। त्यस्तो खालको केस सुनाउँदैछ। अहिले जमाना गयो नि, कसले चाहिँ टिभी बोकेर कुदेर जान्छ? मोबाइलबाट पो चोरी हुँदैछ त अहिले। कसरी हुँदैछ हेर्नुहोस्, एउटा मोबाइलमा हामीले टपअप हाल्दैछ, उसले मोबाइल नम्बर थाहा भयो, उसले 10 पैसा चोर्दैछ, अर्कोको पनि चढ्यो 10 पैसा, अर्को पनि 10 पैसा, ह्युज एकुमुलेसन हुँदैछ। 6 लाख पपुलेसन, भएन 2 लाख 50। कसले गर्ने इन्भेस्टिगेसन? ब्याङ्कमा जानुहोस्, त्यहाँ भइरहेको हुन्छ क्राइम। अहिले तपाईँको डेटा, इभन द कोर्टको डेटामा इन्फ्लुएन्स भइरहेको छ, कसले केयर गर्ने? साइबर क्राइम्स डेटामा हुँदैछ कि हुँदैन? यो स्टामिना तपाईँले पढाउनुपर्छ। त्यसै कारण आई रिक्वेस्ट एभ्री अफिसर प्रेजेन्ट हियर टु काइन्डली रिड, गो थ्रु अल दिस प्रोभिजन एन्ड इक्विप योरसेल्फ। वी निड क्वालिटी अफ द्याट पर्टिकुलर स्ट्यान्डर्ड। त्यो चाहिँ हैदराबादमा म गएँ, अनि अब हाइकोर्टले पठायो, जाऊ लट्ठा तल गएर हेर कस्तो रहेछ संसार भनेर हेरेँ। त्यहाँ त म त कि एउटा कस्तो हुन्छ, एउटा महालठुवा जस्तो डिजिटल उनीहरूले कम्युनिकेसन गर्दैछ, डिजिटल ल्याङ्ग्वेज। यसरी भएको क्राइम यहाँ युकेमा यहाँ भयो, लन्डनमा यहाँ भयो, यहाँ चाहिँ देयर इज नो जुरिडिक्सन एबाउट दिस साइबर क्राइम्स। त्यो च्यालेन्ज आउँदैछ तपाईँको, किनभने तपाईँहरू 58 वर्षसम्म काम गर्नुहुन्छ हो कि होइन? 58 वर्ष त बिचरा रिटायर हुन्छ, सर म त यो गर्नु सक्दिनँ भन्नु सक्नुहुन्न? यदि तपाईँको छैन भने आयोले माथि सुप्रियर अफिसर भन्छ यो सक्दैन, अर्को बिहा त्यहीँ नै भयो डिस्प्यारिटी। एन्ड यु आर टकिङ अबाउट डिस्क्रिमिनेसन रिगार्डिङ माई प्रमोसन। त्यसै कारणले गर्दाखेरि हाम्रो प्लेटफर्मले चाहिँ तपाईँहरूलाई जान्दैन भनेर होइन, हामीले चाहिँ जागरुकता गराउँदैछौँ यसमा। यसपालि हाम्रो एकाडेमिक इयरको क्यालेन्डरमा तपाईँहरूको हेड अफिसबाट जे सजेसन आयो सबै सजेसन चाहिँ इन्फर्मेसन टेक्नोलोजीमा छ। तपाईँको हेड अफिस चाहिँ आफ्टर इन्फर्मेसन टेक्नोलोजी छ है। कुनै आइपिसीको यस्तो इन्भेस्टिगेसन भनेको छैन, अल साइबर क्राइम्सको अफेन्सहरू लगाइदिनु भनेको छ एकाडेमिक क्यालेन्डरमा। त्यसमा जानुहोस् र इन्फर्मेसन टेक्नोलोजी सँगसँगै लगेर जानुहोस्, तपाईँले सफलता पाउँछ।
Relevant portion where your evidence was discussed, it is a pornos. What will happen is that next time you will not make the same mistake, or next time you will know what not to do or what to do. So every POCSO judgment that comes out, if it's investigated by you, kindly reach the judgment. Don't say, what is us? My Erdino. Because court will not just up it just like that. They will have discussed the evidence. Okay? You're ready now.